Counsel, if you are not the first person or first counsel arguing in the first case, please make sure to mute your audio and video.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, Mr. Ross. I don't see you on the video. Mr. Ross, are you with us? Emily, do we have we lost connection?
Yeah, I'm not, and let me check. Mr. Ross, are you with us?
I can hear you. We're having some, I apologize to the court. We're having some audio problems. We're trying to fix them right now as we speak, Your Honor. Can you hear me?
Yes, we can hear you. We're just having a hard time. We don't have any video for you, sir.
Yeah, why don't you try and get them?
Mr. Phillips and Mr. Wells, if you could please unmute your cameras.
All right. Well, thank you, Mr. Phillips, being ready to move up right away. And you and Mr. Wells, you may proceed.
Mr. Phillips, you are muted.
Mr.
Muted.
We cannot hear you.
No. Now, we're good?
There you
Okay.
go.
My apologies.
American Sign Language. I love it. Okay. Thank you, Mr. Phillip.
Thank you, Your Honor. And may it please the court. The fundamental error in this case, candidly, was that the district court and the plaintiffs, for some reason, allowed causation to completely fall out of the case. It is Hornbook contract law that in order to demonstrate a breach of contract, you have to have a duty, a breach of that duty, and that the breach has to cause harm or injury. Causation is a central element of it. The jury was never instructed to find causation, and frankly, the plaintiffs don't really argue anything about causation. Their view of the world is we didn't get the benefit of the bargain, and therefore there's been a breach of contract, and therefore we're entitled to go forward without having to pay under this agreement. But the reality is that's not how you get a breach of contract. You have to demonstrate that but for the liquidated damages provision or the shortfall fee provision in this case, that Drummond Coal would have satisfied the shortfall fees and would have, in fact, shipped coal. But what we know to be true, and the only decision maker in this case who's analyzed the question properly was Judge Urbanski at the rescission stage when he said plainly factors other than the liquidated damages provisions in Norfolk Southern's utility contracts caused Drummond not to meet the minimum volume requirements in C9337. And it is candidly that finding that should be the death knell of the breach of contract claim, just as it was the death knell, along with, frankly, other criteria, for the rescission claim in this particular case. And so therefore, the jury not having been asked to make a finding on causation, the fact that there is no evidence of causation means that this court should reverse. Now you say, is there no evidence of causation? The answer is quite clear. First of all, we know there is no evidence in this record from any of the utilities asking them why they didn't purchase Drummond Coal. I don't think that's an accident.
So, counsel,
Yes,
could I, if I could ask a question, it seems like before you get to whether or not there is evidence or not of causation, the first question is what the first count sought. And I'm not sure the first count at least sought a determination for liability under breach of contract claim. And indeed, they don't have a cause of action for breach of contract. It seems like at least count one's a DJ that your client has breached an agreement, which is part of a breach of contract case, maybe part that would suffice for a defense if you were to seek to enforce the contract. So I guess my question is, assume they just want to show a prior breach and not all the elements in order to recover money from you or recover some other relief from you, but just establish a prior breach. Number one, is there anything wrong with that? And number two, if that's the case, why would they need to show causation?
Well, there's nothing wrong with asking for a declaration, I suppose, of almost anything you want to ask for a declaration of. But at the end of the day, if you want legal consequences to flow from the declaration, then you have to get a declaration that satisfies all of the elements of a breach of contract. You can't just say that we could have behaved better or we could have performed more under a contract than we are required to and say under those circumstances, what consequences flow. Ultimately, it is Hornbook law. In order to make the contract breach actionable in any way, it has to have caused some harm. And that's what's missing in this case, is there is no harm. Why? Because there was never any effort by Drummond to sell coal in this market.
So let me just get one more thing, and I appreciate your answer. But hypothetically, if you had sued, if you had sued Drummond for breach of contract, and they said as an affirmative defense, no, you breached the contract first. Is it your position that in order to offer up that defense, they have to prove all the elements of a breach of contract claim? Or is it sufficient that they just show you breached the contract first?
No, well, breach the contract, of course, assumes in some ways the answer to the question, because breach it in what way? Breach it in is it a breach that carries consequences to it? The example from, I wish I could remember the case, but the Virginia Supreme Court decision where there was a foreclosure and that was followed by a claim by the property owner that the foreclosing company had not satisfied all of the procedural elements before engaging in foreclosure, and therefore said there was a prior breach, and therefore you can't enforce the underlying foreclosure sale. And the court said, well, but if they had they satisfied all of those requirements, would it have made a difference? And the answer was no, because they couldn't cure under those circumstances. That's exactly the same situation here. You can't just simply say we should have behaved differently than we did, when at the end of the day it didn't make any difference in terms of Drummond's behavior. Drummond had a policy of selling its Colombian coal to the European market and to the Alabama market. It generated $11 billion in revenue. It was perfectly reasonable to pay a relatively small amount for this option, as Judge Urbanski found ultimately. And the option was always available there. And so at the end of the day, it is their responsibility, given that they brought the breach of contract claim, to demonstrate that there is, in fact, harm caused by our conduct. And again, to go back to what I was saying previously, first, they have a policy of not selling through Charleston. Two, they made very few bids. The only evidence of any of the bids, in terms of the economics of it from their expert, was wrong. And the only conclusion you could draw is that the price of their coal was significantly higher than the alternative prices of coal that were. Yes, Judge Harris.
Yeah. So is your, I understand your argument, but it just seems that the jury disagreed with you. And so is your position that the jury instructions were wrong? And they allowed the jury to find for Drummond without finding a breach of contract?
Without finding causation.
Or is your position that the jury was properly instructed, but came to a conclusion that no reasonable jury could come to?
Our position is they were improperly instructed. Had they been properly instructed, they could not have reached the verdict.
And you objected to the instructions?
We did object to the instruction. Yes,
and you asked that they be instructed how?
That on causation. But
I thought that was in connection with your prevention claim, and they were instructed that under prevention, they had to the coal company would have to establish that the prevention caused it not to perform. You're saying you were asking for a different causation instruction in addition to that one?
Yes, we asked for a very basic fundamental causation instruction as to breach of contract. I mean, it comes out of the Horn Book breach of contract language, which is you have to have a duty, it has to be breached, and it has to cause consequential harm or injury. And then in order to show consequential harm or injury, it has to be that the breach of contract was the proximate cause. That was the instruction that we sought. And candidly, that's the law. It should have been applied. If it had been applied, there's no reasonable jury that could reach the conclusion that it did under these circumstances, where there is no effort to sell coal into that particular market. There was no impediment whatsoever, not because could it have been an issue? Maybe, but it wasn't. So I think that from this court's perspective, the easiest way to reverse is to simply recognize that there is no breach of contract because there hasn't been any showing of causation. I'm happy to address the issues with respect to the duty of good faith and the actions that we took, and whether there is a breach of contract to begin with, because I think candidly there wasn't. But in my own judgment, the stronger argument at this point is the causation argument. And I would urge the court to reverse on that basis. And obviously there's a whole rescission argument, but if I could, I'd reserve some of my time to be in a position to respond to my colleague's argument on that point. If there are no other questions.
I've got questions. So you do not want us to, you're not here to argue about the statute of limitations today. That's waived
Well, I think the statute, I mean, first of all, I think clearly when you make a finding on July 1st that 2010 is the date in which the contract was breached, particularly as it's conceptualized by the plaintiffs, that you have to file within 5 years of that date. I mean, part of the problem is if you eliminate all of the causation element of the case, then their basic theory of what was the benefit of the bargain was this unfettered right to have a rate that they could bring forth to the utilities. And that unfettered right was breached or lost on July 1st, 2010, and they filed suit 5 years later. So clearly, that's outside of the statute of limitations.
Well, it can't be that clear. If it were that clear, wouldn't you have raised it in your answer?
Well, it was in the answer. We raised it in the unjust enrichment component of the case, to be sure, but it was in the context of should you be able to get money back from us, which is ultimately the theory that they tried to use under the combination of counts 1 and 6. But there's no question that they knew that we thought that the statute of limitations had run. We also raised it at the end of the trial, and the other side didn't object to it when we raised it at that point. And so it was in the case, and clearly, and they were the ones who asked for the jury finding on July 1st, and they got what they asked for. Unfortunately, the consequence of that is, given their conceptualization of the case, everything they wanted, they lost on July 1st, which means they should have brought the lawsuit much sooner than that.
So your position is it wasn't waived because you raised it in the answer in connection with a different claim. Okay. Right. Do we have any cases saying that?
Right. A different claim in the same, but to the same basic problem, which is the claim that's asking us to give up money, which is what we were saying is you can't ask us to give back money unless you act sooner than that. And you didn't do that. And so that's why it's beyond the statute of limitations.
But counsel, I mean, maybe I'm missing that. I mean, statute of limitations is a pretty straightforward concept, and it says it in the rules of civil procedure that's affirmative defense. Or are you saying that if you just use similar words in a related concept, that I mean, maybe that's the argument. I'm having trouble with that one, just given the specificity of the rules.
Well, Judge Quattlebaum, there's no question we asserted statute of limitations in those terms. What we did say was as to count 2, as opposed to saying it as to count 1 and to count 6, if those are manipulated. But the reality is that count 2 was the one in which we were being asked to actually disgorge funds. And so it makes sense that in that context, we would have been specifically concerned about the timing of all of this. But the reality is it would put in issue the question of whether they had brought the suit in a timely fashion. And the answer is, under the findings of their own jury, they didn't act within the time that was appropriate. And I think it's important in that context to recognize there's only really an issue because of the strange way they conceptualize the breach of contract argument, Judge Harris. Again, it's not that we didn't have an opportunity to sell coal. We had no interest in selling coal whatsoever in that market. It's just that we wanted to have this completely unfettered ability to exercise that right if at some point we wanted to use it, and by cutting off, at least to some markets, that easy access, I suppose, that's the breach that requires not only not paying forward, but also rescission backwards. And the reality is that problem, that injury, if that were the injury, that injury was caused when they entered into the agreement with due power. And therefore, it's a complete answer to them to say that they should have brought the suit within 5 years, and having failed to do so, they're barred. As I say, I think the easier answer to the question that posed to the court today is causation.
Well, counsel, I guess before we move on, I do want to give you just a chance to address, I guess, what I might phrase as my overall concern about the case and your argument. So, we start with the jury finding that Norfolk Southern first bargained for these shortfall fees and then turned around and actively worked to prevent Drummond from getting any use out of what it had bargained for. And then the jury finds that that was a breach of Article 13 of the contract. And so, and you're not, I guess you're not arguing about the first finding. We can all agree that Norfolk Southern did this. It bargained for these fees, and then it turned around and actively worked to prevent Drummond from getting what it bargained for. And whether or not it succeeded, you know, I guess is a different question, but that's what it did. And then the jury also found that that was a breach. And I understand you think they weren't properly instructed on the breach, but if I think there was evidence in the record from which a jury could find that that caused, even assuming that they have to show the injury in this declaratory judgment posture, if I think there's evidence in the record, whether it's that strong or not, from which a jury could find, yeah, they breached the contract and it cost them something, where does that leave me?
Judge Gregory, may I answer the question?
You may, yes.
Thank you, Your Honor. Well, I think if you find, in fact, that there is adequate evidence to make a finding of causation, then I don't see that I have any argument left other than obviously statute of limitations. That's still available, and obviously even in that circumstance, rescission wouldn't be available. But I would take obviously issue with the assumption there that there is any evidence from which one could derive any notion that they had any intention ever during the time of this contract of ever selling coal under these circumstances. Okay. If candidly, and it's worth at least making one last point about this because it goes to the question of good faith, because it is true that we entered into other contracts, and you can say that that means we actively participated in some sense.
Well,
but
I'm not saying it. The jury said it. The jury said it after a long trial.
No, I understand. I'm not fighting what the jury actually says in its instructions. But what I am saying is the notion that somehow Norfolk Southern would have gone into this arrangement with the intention of undermining this, and that what they really wanted were these shortfall fees, is commercially absurd, because this was a contract that was going to generate for Norfolk Southern hundreds of millions of dollars in revenue. They had every interest in the world in having this coal shipped under the terms of this contract. They would have made much more money under those circumstances. And frankly, that's how you end up in a world where, like we are today. It's why causation is such an extraordinarily important element of this case, is because what we did, whether it was good, bad, or indifferent, ultimately didn't make any difference to what Drummond did. And therefore, they're not entitled to get out from under the burden of this contract, and we certainly do not owe them anything in rescission. If there are no further questions, I'd like to reserve the time for rebuttal, Your Honor.
Thank you, Mr. Phillips. So reserved.
Thank you, Your Honor.
Mr. Ross, I'm sorry, Mr. Wells.
Thank you, Your Honor. May it please the court, my name is Trey Wells at Starnes Davis Flory in Birmingham, Alabama, and I'm here to represent Drummond Coal Sales, Inc. I think that the context of this contract is very important. There's nothing in this industry like it or any industry like it. In the history of coal shipping, the utilities have always had the shipping contracts. The coal suppliers are essentially bidding in the dark. The contracts are confidential. So the utilities ultimately buy the coal on a delivered price. They're going to pay the shipping, they're going to pay the coal price. Suppliers like Drummond only know one of those components. The shipping component has always been hidden. And frankly, the shipping component is huge. It can exceed the coal price itself, which is odd in any sort of shipping arrangement. And the reason that is railroads like Norfolk Southern have outsized control over these utilities. If you look through the 23 destinations that we have in the contract, most of them, Norfolk Southern is their only option. They have the only tracks running in and out. So they've got a lot of bargaining power to get their rates really as high as they want them to be. Now, this contract was supposed to, for the first time in history, change all of that. Drummond negotiated a contract where for the first time, we would know the shipping cost of our coal to these 23 specific destinations. And that was very important to us. And it was so important to us that we gave up millions in dollars of consideration for that right, for that option, as Mr. Phillips said. We gave up
Counsel, if I could interrupt you, I'd like to just make sure I'm understanding the claims, because the claims, at least that survive summary judgment, to me, it's important to understand kind of what you're seeking in those claims. And first of all, with respect to the first count, are you seeking a declaration of a breach of contract cause of action with all the elements, or are you seeking a declaration for certain elements of a breach of contract, namely that there's been a breach by Norfolk Southern?
Thank you, Judge Quattlebaum. You were right in your original question. We were asserting it as a defense. Norfolk Southern made clear in the district court, if we had not filed first seeking declaratory judgment and asserting various defenses, they were going to sue us because we had not paid the most recent shortfall fee.
So count one is essentially to set up a defense if they try to recover under breach of contract for you. And under that situation, if someone's asserting the prior breach defense to a breach of contract case, do they or do they not have to breach? And if you'd answer that with authority, that would be great.
Yes, Your Honor. The case law in terms of the defense, speak case that we cited in our papers, actually addresses the exact argument. There was the opposing party was arguing, well, look, they can't set up this first material breach defense because they can't show any damages were caused by this breach. And the Bayer Crop Science case expressly rejected that proposition and said Virginia law does not require a party to prove damages in order to successfully invoke the first material breach defense. So the issue of material breach was presented to the jury, and frankly, the statement here that the jury was improperly instructed is the first time I've seen that argued in this appeal. I did not see that in any of the briefing. That, in my opinion, is waived. It can't be raised for the first time in a reply. I'm sure it can't be raised for the first time during oral argument. There is nothing in their brief about the jury being improperly instructed. And the jury, under the instructions, found that there was a material breach, such that we did not receive the benefit of the bargain, which the case law clearly states, if that is proven, then you have a defense to future performance. So what we were buying here was the ability to use our own rates. There was a lot of argument about, well, you could have shipped under the utilities rates too. That is not consideration to us. We always had that option. We always had the ability to ship under the utility rates. We had always been doing that throughout history. Until now, we paid all this money to get the option to use our own rates. And then 6 months after we enter that contract, Norfolk Southern enters into a contract with 5 of our 23 destinations saying it will be a breach of your contract if you use Drummond's rates. They imposed liquidated damages if our rates were ever used. And we gave the example in our papers of the Allen Station. That's one of the power plants in the Duke contract, one of our 23 destinations. Our rate was supposed to be $19.50. So when we're trying to analyze pricing, we look at, all right, we know the shipping cost is $19.50. We can try to find a fair price for our coal so that the deliver price will be competitive. Unbeknownst to us, the shipping cost was actually $25.50 because contractors required them to use their own contract and their own rates. And if they didn't, they had to pay liquidated damages amount of $6 per ton. And really, this case is odd in terms of the timing. The only reason this is not a repudiation case is because Norfolk Southern did all this. If Norfolk Southern had come to us and just said, look, I know we promised you in your contract your rate to Allen Station is $19.50, but we're going to actually charge $25.50. If we had known that, we would have sued and said that was a repudiation immediately. That doesn't require a lost sale because no sale would have happened. It would have just sued under the contract and gotten out of it at that point. The only reason we have 5 years of history beyond that time is because all these contracts were confidential. Norfolk Southern never told us what they were doing. Now, Norfolk Southern argues that there was no express breach here. Now, the Article 13, the jury disagreed with them on that, and the jury was properly instructed on that. So there's evidence that they breached their promise of guaranteed rates to us, and the jury found in our favor. And Judge,
let me, if I could stop you there. I mean, tell me the exact language of. I mean, to me, I understand your implied covenant of good faith argument. To be honest with you, I don't understand the exact language of Section 13 you say was breached.
Article 13 states that the base rates for transportation of your coal will be as set forth in the schedule, and the schedule lists out all the 23 destinations and the rates.
So did they charge you a rate other than that?
The rate that the shipping cost that was actually charged was that plus what they were going to end up charging our customer, which at the end of the day, the customer is paying all of it at the same time anyway. So the effect is the same. And it's the express breach is we were promised one thing, we were given something else.
Yeah, but you don't get, you don't, I mean, I'm sorry to interrupt you, but you don't get to just talk. I mean, again, this may be academic because you have an implied covenant of good faith and fair dealing, but if your claim is Section 13 and that provision says if you ship under the contract, the price will be this, it seems to me to breach that, you'd have to say we shipped under the contract and they charged us a different rate. It seems like you're just saying they did something bad and lumping that under Section 13.
Well, the way Judge Urbanski explained it in the summary judgment opinion and what is borne out in the case law is that what is necessarily implied in the contract is enforced as if it's expressed. And Norfolk Southern tried to make that an implied duty of good faith argument. That is not the law. For example, if you and I negotiate for an option for me to purchase your car, and then I find out you took the engine and you sold it to somebody else, well, there's nothing in the contract that says a car, you got a car, but it doesn't have an engine in it. I think everybody can agree it's necessarily implied you're going to give me the car as I thought I was going to get it when we entered the contract. That's expressed in Pellegrin v. Pellegrin, which is cited in the court summary judgment opinion. What is necessarily implied is much part of the instrument as plainly expressed and will be enforced as such.
If I disagree with you and think you have evidence that supports the breach of implied covenant of good faith and fair dealing, but there's no evidence that would support breach of an express of provision 13, do you still prevail under count 1?
Yes, Your Honor. The jury was asked the question, did Norfolk Southern's conduct breach the contract, whether expressly under Article 13 or under the implied duty of good faith and fair dealing? And the jury's answer was simply yes. So if the jury's verdict can be upheld under any theory, then yes. If Your Honor does not agree with the express breach, but does agree with the implied duty of good faith and fair dealing, the jury's verdict can be upheld under either scenario.
Mr. Wells, just very briefly, you were going through the scenario, but tell me, you mentioned that rather than utilities rates that you had access to before, you were trying to get from under this, not knowing what the shipping cost was. You said a couple of times, we paid to have this new arrangement. How when you paid, you suggest in terms of in that negotiation, somehow Norfolk Southern got more money than it normally would under this contract? Just briefly explain that.
Okay. In the normal circumstance, we're shipping on the utilities contract.
Right, I get that.
So we don't have to give any consideration to Norfolk Southern. We literally just quote the price to the utility, they handle the shipping, and that's something that we're really not involved in. the consideration we gave up to get our own rates
Right.
was we had to guarantee that we would either ship a certain amount or pay roughly $7 million a year. Plus, we had to pay about $10 million for infrastructure upgrades that Norfolk Southern still has to this day. Without our own rates, if we're just using utilities rates, we didn't have to give up any of that consideration.
So that was the underpinning of the contract in the deal itself, right?
That's correct, Your Honor, and that's why we think the pointing to the ability to use the utilities rates is somewhat of a misdirection, because that is not the purpose of the contract. There's no consideration flowing to us by Norfolk Southern saying, you can use the utilities rates and you give us money and guarantee us however many shipments. We don't have to do that. We've always been able to do that, and all of our competitors were able to do that today.
Thank you. You can proceed with your argument. I thought that was correct. I just want to make sure. Go ahead.
Thank you, Your Honor. And Judge Quattlebaum, to move on to the applied covenant of good faith, it's undisputed in this case that Norfolk Southern promised us usable rates we could actually use with 23 specific customers. It is also undisputed that they penalized those customers if they ever use their rates. In fact, they made it a violation of a legal duty, a violation of their contract to use our rates. The evidence also showed why they would be motivated to do this. And Mr. Phillips inaccurately stated Norfolk Southern would have made more money had we shipped. The evidence does not bear that out. If you look at the closing argument, we explained to the jury how to get to this calculation. It's in trial exhibit 169C. We did actually ship some coal to these destinations in the early part of 2010. And the profit that Norfolk Southern made off of those shipments was less than the profit that they made off of just collecting liquidated damages from us. So they had every incentive to not want us to ship under this contract, and then end up making more money than they would have had they shipped. And not only do they make more money on the liquidated damages, they get paid two ways. They make more money from us on just free money, liquidated damages. But number two, they're shipping the coal anyway. They have the only rail in and out. So they get paid for those shipments. The numbers, the revenues that Mr. Phillips was talking about, they're getting those revenues. Those coals are going in from our competitors, but they're also getting an extra boot on top from us of $7 million a year, which is pure profit. They don't have any costs involved in that. And the evidence also showed that they knew what they were doing was wrong. That after this contract, if I can just finish this one statement, Your Honor. After the lawsuit was filed, and we started raising issues and calling them on this improper practice, they changed one of their contracts, and for the very first time said, all right, in your contract, you can either use your rate or you can use Drummond's rates, and it will count. We will not penalize you. So the jury had all of that evidence of not only improper conduct, motivation to engage in improper conduct, and also acknowledgement of that it was improper. They had more than enough evidence to come to the conclusion that Norfolk Southern was acting in bad faith.
Thank you, Mr. Wells.
Thank you, Your Honors.
Mr. Phillips?
Thank you, Your Honors. Hopefully you can hear me.
Yes.
Great. Judge Quattlebaum, let me answer the specific question you asked my friend on the other side, which is, can you have a declaratory judgment for something called a breach without actually demonstrating all of the elements of a breach of contract because it's in the declaratory judgment mode? In the case we cited on page 22 of our reply brief, Green versus Gable Gould, 597 Southeast 2nd 81, the Virginia Supreme Court said explicitly, no, if you're seeking declaratory relief claiming a breach of contract, you still must assert and prove.
But that begs the question, doesn't it? Are you seeking declaratory judgment kind of as in lieu of a breach of contract, or are you seeking a declaration of a prior breach which you can use as a defense if Norfolk Southern asserts breach of contract?
Right, and as I understand the Green case, what it's saying is that in order to make a meaningful defense, you still have to show harm. There still has to be a demonstration of harm, whether you do it directly as a claim for breach of contract or whether you seek it as a matter of declaratory relief. It's still a black letter component of contract law that you have to show that there's been injury that flows from it. And my friend didn't say anything about any injury that flowed from any of this. He talked about that they didn't have this unfettered ability to use the particular rates. But even in response to the specific question that you asked, Judge Quattlebaum, which was, did they charge anything other than the base rates in this case? The answer to that question was no. We always charged the base rates. Was that the ultimate underlying economics of the deal? No, but of course there are 1,000 variables that go into the economic underpinnings of the deal. What is absolutely clear, and I'm not going to get into rescission because my friend didn't raise anything with rescission on his cross appeal, so I'm content to let that rest as matters stand. But at the end of the day, when you're talking about our failure to come forward. I mean, he claims that, if we had told them that we were going to enter into these kinds of agreements, which candidly I think that they knew about anyway, but if we had told them that we were going to have these third-party contracts with these requirements, obligations imposed on them, they would have declared that to be a complete breach and gone forward. The truth is, this is where Article 27 is so critical, and I think it made a huge difference in Judge Urbanski's analysis. Article 27 is the one that says it's the obligation of Drummond, when they're having problems selling this coal into that market, to come to us, and we will work in good faith to try to help them. They never invoked that provision. They never took advantage of what the contract specifically provides with respect to what to do when they're having difficulty selling. And why didn't they take advantage of that? It goes back to the basic point I've been making all along. They never had any intention throughout the entirety of this contract of selling coal in this particular market. Not because it wasn't a good option to have available, right? It was always the possibility that Europe would start to regulate coal more aggressively and make it therefore significantly less valuable. You couldn't use coal, and therefore the European markets could be shut off. It's always possible that the U.S. domestic efforts might close down coal mines altogether, making imported coal from Colombia extraordinarily valuable, and they had this option. And that's the option, Chief Judge Gregory, that they paid for. That was specifically what they paid for, was to have the ability to come in if market changes, if market conditions changed. Halfway into this agreement, I think they pretty much concluded market conditions were not going to change, and at that point, they started to look for an excuse to get out from under this agreement. Remember, this was originally brought as a force majeure action and then converted into a combination of breach and prevention and any other theory that they could throw against the wall. At the end of the day, it was their responsibility to prove that there was a cause of some harm to them, and they never proved that. And the only person who ever analyzed the question in terms of that causation element was Judge Urbanski, and he specifically said they never intended to sell coal in that market, and therefore there is no breach of contract, and therefore the court should. Yes, Your Honor.
Can I just ask, so how much of this kind of injury argument turns on the failure to instruct the jury on it? And I guess, like your colleague, I am surprised to hear about this argument for the first time at oral argument. So, I mean, is your claim that the jury was misinstructed or not really, because it's not in your brief?
No, I mean, our claim is that the jury, I think there's no doubt the jury was misinstructed because the causation wasn't put into the case. But
you don't want us to rule.
Right. Well,
I mean, usually that's a big deal. Like if a jury is misinstructed before a 5-day trial, and that's your argument, we would have, at least I would have expected to hear about it before today.
Right, but that's if what you're seeking at the end of the day is a new trial with a properly instructed jury. That's not what we're seeking here. What we're saying is this jury was not instructed properly. There is no causation component to the case. The finding doesn't, so you cannot rely on the jury to create, as somehow having filled that void. And our view and our argument is, and it goes back to the question you said, if you can find any evidence of causation, would that be a basis for affirmance? The answer is yes, because we didn't ask for a new trial with a properly instructed jury. But I'll go back to what I answered you. There is not a shred of evidence of causation because it was the plaintiff's theory all along that they never had to prove anything with respect to harm. And at the end of the day, they did. And that's why judgment as a matter of law should have been entered in Norfolk Southern's favor, Your Honor. If there are no further questions, I'll rest, Your Honor. Thank you.
Thank you. Mr. Wells, you have some time.
Thank you, Your Honors. The issue of injury, I think Norfolk Southern concedes you don't have to prove damages. I mean, they concede that because they have to, because that's what the law says. But yet their whole argument of what we didn't prove was damages. They say we have to show a specific lost sale and be able to show essentially lost profits. That is not what the law states. Virginia law, Horton v. Horton case, it was a prior material breach case where the spouse, the wife, did not get a signed power of attorney. There was zero damages proven as it related to that, but they still said that was a material breach. It was a material part of the contract, therefore it prevented her from suing for breach of contract. The Schmidt case that we cited, we actually cited it in the section talking about implicit obligations of the contractor are just as much expressed as those that are in the words. But the case there was a first material breach case, and the employer said, well, implicit in this contract was that the employee would accurately report his hours. And because he breached that, he can't now sue us for underpaying him. And this court found that that was a first material breach, and the employer was excused. There is zero damage analysis in that case. And in fact, I don't know how you could possibly even conceptualize the employer somehow being damaged monetarily in any respect by the employee failing to report all of his hours. The Mobile Oil case goes directly to this issue, and it's interesting because Norfolk Southern's counsel in this case actually wrote the briefs in the case, and we would recommend the court, if it hasn't already, to review those briefs because I think it explains the law in this area very, very well. The government in that case had a contract. Basically, the drilling companies had an option to try to explore drilling, and the government said, we'll do it under this certain regulatory scheme. The government then goes out and changes the regulatory scheme, and the oil company sued for material breach, for repudiation, because it was in front of them. Had it been hidden, they would have gone backwards and sued for material breach. But the whole of the government's argument was, well, look, they were never going to be able to drill anyway. Because North Carolina objected to their drilling plan, it didn't matter what our regulatory scheme was because they were never going to be able to drill. And really, that was not a disputed point in the case. They were never going to be able to drill for oil. And the government said, so they can't, whatever our regulatory scheme did, it didn't cause them to not be able to drill, and therefore they can't sue. They can't get the money they paid for this option because the option was never going to be successful. Well, the Supreme Court in Mobile Oil expressly rejected that argument. The court said what they thought was an opportunity to try to drill under this regulatory scheme that the parties agreed to in the contract. There's nothing in the contract that prevents the government from enacting new laws. The government can always enact new laws, but that doesn't mean that by doing so that they can't be interfering with the contractual rights of their counterparty. And I thought the Supreme Court gave a very good example, which I think really undercuts Mr. Phillips' arguments, that if a lottery operator sells you a lottery ticket but doesn't deliver the ticket, you didn't get what you paid for, you should get your money back. It doesn't matter that you weren't going to actually win the lottery. I mean, the lottery operator can't come in and say, well, look, these are the numbers they picked, and it didn't win. So no harm, no foul. They paid for something. They paid for an opportunity which was not provided to them. Norfolk Southern, we paid for an opportunity to use our rates. And the jury found, I don't even think it was disputed, that Norfolk Southern took away our ability to use the rates that were promised to us. Mr. Phillips talked about Judge Urbanski's findings after the jury's findings, talking about that Drummond chose not to sell, didn't really try to sell. Well, that was Norfolk Southern's entire theory in front of the jury. The jury was presented all of that evidence. The jury was presented competing evidence by us of significant efforts to try to sell coal into this market. We were bidding, I think it was 52 million tons over the course of the contract. We were in constant negotiations. We were bidding coal at $4 million losses. In fact, it got to a point where we just started cutting off the $7 million penalties that we were getting and just cutting that off the coal price to see if we could get coal moving. The jury heard all of that evidence and rejected it, and we think that Judge Urbanski, in coming to a contrary conclusion, in rejecting restitution rescission, essentially giving us our money back, contravened the jury's verdict, which has a lot of discretion in affording an equitable remedy, but a very serious limitation on that discretion is when there's a jury finding, he cannot contravene it, and we feel like he did in this case.
All right. Thank you, Mr. Wells.
Thank you, Your Honor.
Thank you, Mr. Phillips. We can't come down and greet you in our normal tradition of the Fourth Circuit. We hope very much that we appreciate your arguments and your help in this case. Hopefully you both will be safe and stay well. Thank you so much.
Thank you, Your Honor.
Thanks very much.
Judge Gregory,
Yes.
I need to readmit Ms.
Messina,
Sorry, Chief Judge Gregory, I couldn't hear you there.
Oh, you may proceed. Yes.
Thank you, Your Honor. Good morning, Paul Mazzina for the appellant, Sammy Lewis Stokes. Your Honors, Sammy's childhood was marked by severe abuse and neglect. His mother and stepfather were alcoholics who were notorious for their violence and for the way they mistreated Sammy and his sister Sarah. This is classic, compelling mitigating evidence, but the jury didn't hear a word about it. Instead, the defense's only penalty phase witness was a prison warden who testified that if Sammy didn't behave in prison, he could be killed. As a result, the jury didn't hear anything that would have humanized Sammy or helped explain his behavior. And in at least 4 cases, Williams, Wiggins, Rompia, and Porter, the Supreme Court has overturned death sentences based on trial counsel's failure to investigate and present similar mitigating evidence to what was available here. And the court did that even under the deferential AEDPA standard that applied in those cases but doesn't apply here. If those cases mean anything, they mean that Sammy Stokes is entitled to a new sentencing hearing and one fair chance at convincing a jury to spare his life. I want to address the merits of this claim and also why PCR counsel was deficient in not raising it. And to the extent there's time and the court has questions, I'll also address the issue of Mr. Sims' conflict of interest. So, Your Honor, there's no dispute that Sammy's childhood was filled with the kind of trauma and abuse that the Supreme Court has held is important for a jury to consider. And I won't try to describe all of that evidence now. I know the court is familiar with it, but just briefly, there's no dispute that Sammy was routinely beaten and whipped with electrical cords, often in front of friends and neighbors, that his stepfather beat his mother constantly, sending her to the hospital on multiple occasions. Both Sammy and Sarah experienced sexual abuse, and because their parents were constantly drunk, they had no adult care or guidance. They barely attended school, and they would often steal food from neighbors just to have something to eat. And I think it's clear under Wiggins that trial counsel's investigation of these facts was woefully deficient. Just as in Wiggins, that investigation identified red flags that should have prompted further investigation, but trial counsel didn't pursue them. And I think to see how deficient this investigation was, really the best thing to do is just to compare the notes of trial counsel's investigator, Ms. McKay, which start at page 2527 of the joint appendix, and contrast them with the subsequent investigation by Ms. Dean. And her notes start at page 2546, and then they pick up again at page 3213. Ms. McKay started interviewing witnesses less than 3 weeks before the trial, and she was actually still conducting interviews while the trial was going on. She talked to a handful of relatives, ex-girlfriends, several of whom said they didn't know Sammy or his family well. And she learned from Sammy's sister about their parents drinking, about the violence in the home, at least at a high level, but she didn't follow up. Now, you look at what Ms. Dean did, and it's much more of a proper mitigation investigation. She talked to teachers, neighbors, people in the community, and from all of those interviews, a very clear and consistent theme emerged, and that theme was everybody knew. Everybody in this community knew how bad Sammy and Sarah had it. One neighbor said everybody knew that these kids weren't cared for and were pretty much raising themselves. Another said people would talk about how the kids should be taken away, but it never happened. And one interviewee even said that he thought that Sammy's stepfather, Richard, trained Sammy to be how he is. Trial counsel didn't learn any of this because just like in Wiggins, they had these red flags of alcoholism and issues in the home, and they didn't follow up on them. And you can see this clearly, I think, in trial counsel's testimony in the hearing below. So Mr. Johnson testified that he thought Sammy just had, in his words, a poor upbringing that was similar to the struggles that other African Americans were experiencing at the time. That's just not the reality. The reality is witnesses consistently said that Sammy's situation was much worse than even other people in this poor and struggling community. Now, under Wiggins, it's clear that there can be no deference. There's no need for any inquiry into whether trial counsel had strategic reasons for not presenting mitigating evidence, because if they didn't do an adequate investigation, they can't have made an informed decision about that, and that's the end of the deficiency prong. But if you do look at what trial counsel said about why they didn't present the mitigating evidence they had, it really doesn't hold up to any kind of scrutiny. They never gave anything like a coherent explanation. They basically just said they had a feeling that this jury wouldn't be receptive to mitigation. And they couldn't explain where that feeling came from. To the extent they offered any explanation at all, it was just based on bogus racial stereotypes. And I point you in particular, Mr. Sims, around page 3469 to 72 of the joint appendix, he has some vague references to the overall look of the jury, to its composition, including the fact that there were African Americans on the jury, and how the jurors reacted to some things during trial. He doesn't say what. And of course, this jury never heard any mitigating evidence, so Mr. Sims had no opportunity to observe how the jury would have reacted to that evidence. And Mr. Johnson, I already mentioned at page 3524, he said, how do you go to a jury and say, look, we want you to look at the fact that he had a poor upbringing, particularly African-American, which a lot of us had struggles coming up. Again, nothing in the record suggests that the 5 African-American jurors, or for that matter, the 7 white jurors, had experienced any struggles that were remotely comparable to what Sammy went through, or that any of them would have been unable or unwilling to consider mitigating evidence. And
so counsel, if I could ask, follow up on that. I hear your arguments, and there isn't, and I've read that, a number of times, and I guess this is my question. If trial counsel feels that the mitigating evidence, and I know you had, let's just assume in this question that there was an adequate investigation. I know you contest that, but let's assume they have the evidence, and there's a belief that given the gruesome nature of the charges and the evidence, that trying to explain it in that way, based on his interpretation of the way the trial's going and his view of the jurors, that it's going to do more harm than good. Is it your testimony that he doesn't have the ability to make that kind of judgment based on his feelings of way that on the way the trial is going? Is that, and that just seems like, I mean, I know this is an extremely serious matter, and there's ABA guidelines, so I know it's not your normal case, but that happens a lot in trials. And I'm just trying to see how we consider that, or do we just throw that aside if you don't think it's adequately explained?
Sure, Your Honor. A few points about that, and thank you for bracketing the question of the adequacy of the investigation. I think the basic point in response is that developing and presenting mitigating evidence is such a core part of capital representation, especially where, like here, the defendant's guilt isn't in doubt. And so really, convincing one juror to spare the defendant's life is trial counsel's entire job in this case. The decision not to put on any social history evidence at all when so much of it is available is an extraordinary and momentous one. It demands a commensurate justification. And we're not here saying that counsel can never make that decision not to present it, but I think it can't be enough for trial counsel just to say, I had a feeling it wouldn't work. And that feeling was based on the juror's race and some vague references to their demeanor. And of course, it wouldn't be unexpected at all in a case like this that the jury might have been reacting with disgust or horror to some of the facts of the crime. That's typical in death penalty litigation. But the Supreme Court has consistently found prejudice where substantial mitigation evidence existed and trial counsel didn't present any of it, even through the lens of AEDPA, which doesn't apply here, and even where the aggravating evidence was extreme. And I point the court in particular to Rumpia, which of course was available to PCR counsel. In Rumpia, I think it's a good yardstick for how the Supreme Court has viewed these kinds of cases. The defendant there stabbed a bar owner and set him on fire. The jury found torture, which of course the jury here did not find. And the jury in Rumpia also heard about a history of violent felonies the defendant had committed, including a rape in which he cut the victim's breasts with a knife and held her at knife point while he raped her for an hour. And the court in that case didn't even view prejudice as a close question. It said it, quote, goes without saying that if this jury had also heard evidence of Mr. Rumpia's all of the abuse and deprivation that he had experienced as a child, which was very similar to what was available here, it goes without saying that might have swayed at least one juror to vote for life. So I think in light of that, it's very hard to say either that there was no prejudice here or that you can rely on trial counsel's vague statements about we had a feeling that this wouldn't work. And of course, the jury here was very close to voting for life. We know the jury, even though they didn't hear any mitigating evidence at all, they didn't find the two key aggravating factors. They didn't find torture, which the prosecution said in closing was its most important aggravating factor, and they didn't find the murder of Doug Ferguson. And we know they were seriously considering a life sentence. The jury sent out a note asking about the privileges that Mr. Stokes would have if he were sentenced to life. Mr. Sims, who the state says had such a good read on this jury, he testified that he felt the jury was, quote, looking for that concrete thing they could hang their hat on to give him a life sentence. And the state even elicited testimony from Mr. Sims that a juror called him after the trial and said, quote, we were looking for a way to give him life. So this is a jury that was almost in equipoise, even without having heard any mitigating evidence at all. Trial counsel was able to say in closing the facts were all one way, and this jury still considered life. So I think if they had heard some of this abundant mitigating evidence that was available, there's certainly at least a reasonable probability that some juror would have voted for life. And I think a lot of what I've said, I'll turn to PCR counsel. A lot of what I've said about the merits really also goes to why PCR counsel were deficient, as they themselves admitted, in not presenting this claim. They admitted that there was no rational reason for dropping the claim, which I think was clearly stronger than most, if not all, of the claims they presented. And they admitted that they basically just lost sight of this claim because they became distracted by what they called the shiny object of the intellectual disability claim. And you can understand how that happened, right? Atkins, at that point, was a recent decision. They thought that the intellectual disability claim would give them a vehicle for talking about a lot of the same evidence as the mitigation claim in terms of Sammy's deprived childhood. But the disability claim was better because if it was successful, it would mean that he couldn't be executed at all, as opposed to just getting him a new sentencing hearing. So they shifted their focus to that. But then by 2007, they knew that that claim was not viable. It hadn't worked out. And at that point, the state admits they could have gone back to the original mitigation claim, which was very strong, but they just didn't. They didn't think about it. It didn't occur to them at that point to go back and say, because we don't have an intellectual disability claim anymore, let's go back and revive the mitigation claim. You contrast the strength of the mitigation claim with the 7 other claims they brought. So there was no winnowing here. There was no, we're just going to present our strongest claims. Of those 7 claims, 4 of them PCR counsel ultimately abandoned after 5 years without even seeking a ruling. 2 more were claims alleging ineffective assistance of appellate counsel for failing to raise an error that was undisputed was not preserved at trial. So those claims were obviously not viable. And I really don't know how any reasonable lawyer could have looked at the trilogy of cases that PCR counsel had available to them at that point, Williams, Wiggins, and Rumpia, and not thought that this mitigation claim was worth pursuing. And I think Mr. Laminack said it pretty well. At page 3028 of the appendix, he testified, he said, I can't remember a case that's this aggravated where no mitigation was presented at trial, and then literally no mitigation was presented at post-conviction relief action. He said, I don't know of a case in which I was involved where that ever happened, and I don't think it should have happened here. And I think that's clearly right. It shouldn't have happened here. Just briefly, Your Honor, of course, the other side of the coin from what trial counsel didn't present is what they did present. Their sole penalty phase witness was Mr. Aiken, who was presented as a witness on prison adaptability, but who didn't testify that Stokes was adaptable to prison. His view of prison adaptability was that if a prisoner commits violence in prison and is punished for that, that's evidence of adaptability. The prosecution, I think, reasonably in closing called that Alice in Wonderland view of adaptability, said it didn't make any sense. And there was no reason to think that that kind of testimony was going to persuade a juror to spare Mr. Stokes' life. So it's not as if trial counsel had some great mitigation strategy to pursue in lieu of presenting actual traditional mitigating evidence.
Counsel, sorry, it's Judge Harris. Can I just ask a quick question? And I think you've probably answered it with the structure of your argument. But if, just assuming hypothetically, we agreed with you on your claim involving the mitigation evidence, there'd be no need for us to reach the other 2 claims you've put forward, right?
That's right, Your Honor.
A new sentencing is a new sentencing. Okay.
Exactly. Thank you. And I see my time has expired, so unless there are more questions, I'll save what's left for rebuttal.
Thank you, Mr. Messina. Mr. Ross.
May it please the court. Strategic decisions made after a reasonably thorough investigation are virtually unchallengeable. That's what this case boils down to. Second guessing an attorney's decision 20 years after the fact. Mr. Stokes characterizes this investigation as cursory, as half-hearted, but simply saying that doesn't make it true. This case boils down to what did trial counsel do? The first step in assessing a Strickland claim is looking at the reasonableness of their investigation. And Mr. Stokes' case falls apart at step 1. Rather than focusing on what trial counsel didn't do, it's important to address what they did do. And in this case, trial counsel hired 2 fact investigators, one of which was specifically devoted to developing mitigating evidence. That person interviewed family members, friends, employers, girlfriends, all the types of folks that you need to develop mitigating evidence. Trial counsel also retained Dr. Augustus Rogers a professor of social work at the University of South Carolina. He interviewed Mr. Stokes. He was there ready to testify at trial, and he was going to testify to a lifetime of deprivation and the like. Social history was just one piece of defense counsel's strategy at sentencing. They also had a psychiatrist available. They were going to offer evidence of Mr. Stokes' AIDS diagnosis. Their argument was going to be with Mr. Stokes' frail condition. Remember, this is 1999 with an AIDS diagnosis. With that frail condition, he was unlikely to hurt anybody in prison. They were also going to argue with that condition, he already had a death sentence, that the jury wouldn't need to make that difficult decision. Additionally, trial counsel had a neuropsychologist who was there prepared to testify. He was going to discuss brain abnormality. But Mr. Stokes himself pulled the rug out from his own counsel. He adamantly refused to allow trial counsel to present that testimony. And at that point,
So counsel, if I could stop you there, this is Judge Quattlebaum. Assume that, I hear you on the AIDS strategy, and that, as you point out, may have been taken away. The trial counsel has, other mitigation, kind of arrows in its quiver, and they don't use them. I mean, I get that your plan A didn't work out. Seems to me the question is, okay, what do you do then? And, he, doesn't put up the mitigating evidence. That's a traditional approach to these cases. What's your explanation that, that he doesn't adequately give a justification for doing that?
Two reasons. Number one, he specifically saw the reaction of the jury as the details of this brutal crime came in. This was not an armed robbery gone bad.
Counsel, can I ask you something? Because this is the part of the story I just have trouble understanding. What did he think was going to happen? What surprised him about the jury's reaction to the details of this gruesome crime? What did he learn about how did that surprise counsel and make him decide, oh my goodness, let's not call the mitigation witnesses who are sitting outside the courtroom?
Well, it's one thing to review a file, review autopsy photos, review the state's case and discovery. It's another thing to see how horrendous the jury is going to interpret that. And that's what happened.
Okay.
You can start with an assessment of just how bad it is, but until the jury physically reacts, at that point, it's just your assessment. And this was not an armed robbery gone bad. A woman was raped, murdered, scalped. Her vagina was cut out. She was left to rot in the woods. And again, it's one thing to review a cold case file, but when you see a jury's reaction in court, you got to respond. Everybody has a strategy.
Mr. Ross, can you hear me?
Yes, sir.
Okay, thank you. You said when you see that reaction, fair enough. I mean, I don't know how it's Judge Harris' question. I don't know how you could expect going through this case not to receive that. Any human being seeing anything close to this, I'd be afraid of the jury who was hearing the case if I didn't have that reaction. That's a part of your strategy. But to see that, let's take that. Let's say if he was surprised. Wouldn't that mean that you have to double up what you got to do to try to respond to that? But don't you agree with that? You're a lawyer. You're a professional. I mean, you can't go crumbling, seeing that. Don't you then have to say, wait a minute, I really have to double down. Anything that I thought maybe I would do a little, I have to do more. Wouldn't you agree that as a professional, as a lawyer, that would be your reaction? I'm going with your theory that this was an incredible taken aback moment. Wouldn't it not?
Well, if Strickland makes one thing
I'm not talking about Strickland. I'm talking about what you open this up and saying that was an horrendous moment for him. I'm asking you, wouldn't that make a professional person, a lawyer in a death case and say, wow, I really have to deal with this. And my mitigation is the only part that I can deal with at sentencing, right?
Trial advocacy is as much an art as it is a science.
I agree with that. I did it for 20 years, and you're right, you absolutely did. But go ahead.
Mr. Stokes makes a point that you only need to convince one juror to side with you, and that is a true point. But you only get 12. So if you start out by alienating half of your jury, you're making the job of convincing just one person that much more difficult. And that's what trial counsel would do.
How are you alienating the jury to tell them that this boy saw his sister being put out for prostitution, that they had to steal to eat, that they were sexually abused? That's alienating someone?
Trying to mitigate the horrendous details of this crime with that particular jury in 1999 Orangeburg County, South Carolina, could be offensive. And the person in the best position to understand that was trial counsel. He lived in that community, he tried cases in that community, and he saw just...
I have one last question. I don't want to dominate this, but let me tell you, I'm going to assume everything you just argued. All right. But at the end, you don't put on mitigation. Doesn't he have to say to the jury he should live? Would that have to be offensive? If it's offensive to say that his childhood is offensive to them, then it has to be doubly offensive to him to stand up and say at the end, don't kill him, let him live. I don't understand that. Explain that to me, Mr. Ross.
Trial counsel was doing just that. Trial counsel knew that in arguing for life, that social history that they had was not entirely favorable. He knew that in offering particularly the sister, that he was going to offer negative details that would be devastating to his claim that the co-defendant was responsible for the more egregious aspects of it. Yes, ma'am.
I'm sorry, did trial counsel say that at the hearing, that the reason he didn't put on this testimony is because he was worried about bad stuff that would come out? I thought he went thoroughly with the first thing you said, which is he thought it would offend the jury to put on a mitigation case.
He did. Later on in his testimony, he said he was concerned that he was concerned about negative information of his background coming out. And we know for a fact that he reviewed the investigators' file in this case. He billed for it. He met with the investigators. And the devastating information, particularly again from the sister, is in black and white in the investigator's file. Make no mistake, Sammy Stokes is guilty of the offenses charged. There's no doubt that he participated in the rape. He participated in the murder. He participated in the murder of Doug Ferguson. What trial counsel was trying to do was place some of the blame on the co-defendant charged, and that was Mr. Martin. He was trying to put the blame on him for scalping that woman, cutting out her vagina.
Okay.
And he made that argument throughout the guilt phase, throughout the sentencing phase, and if he offers the sister's testimony, if he offers the evidence of his social history, he's going to expose the jury to the relationship Mr. Stokes had with that co-defendant growing up. And that was not a positive relationship for Mr. Stokes. That is not something he wanted the jury to understand. There was evidence that Mr. Stokes beat him up his whole life, that he bullied him, that Mr. Martin was afraid of him, and you simply can't argue to the jury, this guy over here is a real bad guy. The state made a deal with the devil. When
I just want to make, counsel, I just want to make sure, because so this is a different argument. So which, I mean, I guess your argument is that for two independent reasons, each of which was objectively reasonable, this lawyer decided not to put on any case at all in mitigation, by which I mean an effort to humanize the defendant or bearing on his moral culpability. Two separate and independent reasons. One was he thought it would offend the jury, and the other was he thought it would, that if you ask, say, a social worker to come in and talk about how he was beaten by his father, that would bring in evidence of his relationship with his co-defendant.
Yeah,
so those
correct.
two separate reasons.
Two separate reasons, and Strickland makes clear that this
Okay.
again is an objective standard. So
Okay.
what-
Okay. So can I ask you? So is your I just so I understand where we are doctrinally. Your bottom line point is that this is not even a substantial claim for Martinez purposes. We should not be reviewing it at all, or that it's substantial but it fails on the merits.
It's not a substantial claim, and even
You think
if
this is not a substantial claim? Okay.
this is not a substantial claim, and if you're looking at Martinez, you still have to overcome. Mr. Stokes still has to overcome PCR counsel's alleged. You still have to prove PCR counsel was deficient in their handling of the case, and I think their investigation shows again they're acting reasonably. They had all the information that trial counsel had. Again, they hired additional folks to investigate the claim. They developed that, and they confirmed that social history was not entirely beneficial, that Mr. Stokes was known as the terror of Branchville, that everybody in that small town knew about that social history. And we know for a fact that the prosecutor would have known that as well. Trial counsel testified at the evidentiary hearing that the police told him that his client was the terror of that small town.
Can I ask you, counsel? I have an overall concern that I want to give you a chance to address. It seems to me, and we would need to be really careful if we wrote an opinion agreeing with you, because it seems to me that a lot of what you're saying just kind of flies in the teeth of the Supreme Court's cases on mitigation evidence. It is always the case that by the time we're talking about mitigation evidence in a capital case, the person we're talking about has done a lot of bad things. Like, by definition, this is somebody as to whom there is negative information out in the world. But by definition, you will be asking a jury to consider something about the human nature of the defendant who has committed this terrible, terrible crime. If it were sufficient to say, well, the jury might be offended, and anyway, there's a lot of bad stuff about him too, why would there... That just seems sort of totally inconsistent with the Supreme Court just repeated, like it's the one thing in these capital cases where they have been so clear and so emphatic so many times. You have got to put this evidence in front of a jury.
Your Honor, there is no firm rule that you have to. Wiggins itself says that mitigating evidence is not required in every case. And in addition to Wiggins, there's Strickland itself, the granddaddy of them all. That was the case that we used to cite the standard for ineffective assistance of counsel claims. But in that case, the defense attorney didn't provide or didn't offer any mitigating evidence at that sentencing proceeding. You also have Berger versus Kemp cited in our brief, a situation closely resembling the facts of this case where you have a charged soldier down at Fort Stewart and he's trying to point the finger at another co-defendant saying, well, I did it, but I'm not as bad as this guy. And the Supreme Court found that was a reasonable decision to make. Garden versus Wainwright, another case from the Supreme Court, also involved not offering any mitigating evidence whatsoever. So there is no firm rule that you have to do it. In fact, Strickland says the opposite. Strickland says attorneys have wide latitude in how they're going to present a case. Even the best criminal...
Yeah, no, I do hear what you're saying, and I think I probably overspoke or overstated the case. But if it were a sufficiently good reason not to put on mitigating evidence, that there is also negative character evidence about the defendant, why would anyone ever have occasion to put mitigating evidence on? Why would the Supreme Court so consistently insist that it be investigated, that jurors find this mitigating, that they do find backgrounds like this to be mitigating, to lessen a defendant's moral culpability? If all it takes to make all of that go away is that the person has also done bad things, I feel like we are left with a null set.
This is not a situation where the person had just done bad things. This is a case where those bad things would shoot him in the foot on the defense he was trying to make. And again, one attorney may decide that was a reasonable response. One attorney may handle it a different way. The issue is not whether I would make the same decision if I were wearing my trial attorney hat. The issue is whether or not that decision was objectively reasonable. And it is objectively reasonable not to offer evidence that you know is going to take away your best argument in the case. And that was pointing the finger at the other defendant, particularly when you know that the jury may be inclined to find that excuse or that attempt to mitigate these details as offensive. And additionally, it's important to point out the prejudice prong in this case. Mr. Stokes has to show deficiency of counsel, trial counsel. He has to show deficiency of counsel, of PCR counsel, but he's also got to show prejudice as well under Strickland. And if you look at prejudice, you've got to consider the entirety of the proffered evidence. What was actually presented at the federal evidentiary hearing? You got to consider the good, the bad, and the ugly. And Mr. Stokes wants to talk a lot about the good, but he ignores the bad and the ugly. And the evidence that came in primarily through Dr. Garbarino. And with all due respect to him, he lacked credibility at that hearing. The magistrate noted it from the bench when he was confronted with an email he sent to federal habeas counsel. And in his own words in that email, he's revealing him. And that is a Perry Mason moment. That is a Matlock moment. That's every prosecutor's dream, to be able to confront an expert with that email. And if that had happened in front of the jury, the wind comes out of his sails. That is game, set, match for the state. There's also overwhelming, aggravating evidence here. So in looking at what would have been presented with their proffer, compare it with what was presented in 1999, and using Dr. Garbarino is something like shooting a freight train with a BB gun. It's going to have no effect. This is a case where the man planned these crimes while in prison, while allegedly on good behavior in prison. He gets out, and within a week, he's committed two of the most brutal murders that you can imagine. He mutilated and raped and killed a woman, and then he mummified a man with duct tape. What Garbarino had to say was not going to affect anything after the jury heard those facts, heard the details of this crime, heard his history.
Mr. Ross, Mr. Ross.
No, you go, Judge.
Excuse me, Judge Harris.
No, please.
Well, we all were children, so I think we all had that commonality. Can you imagine growing up and having a childhood like that? I mean, you talk about, yes, what he did was horrendous. It's a case that begs, it cries out to say, how did this person get to this point? I can't, it's an incredible case and opportunity. I don't care what you say about what he did and all those things, bad things, like Judge Harris said. I don't think they thought in a way that this person was a choir boy and this was the first rodeo. But the point is that things can happen in your childhood that you never overcome. I mean, one instance, for example, seeing a parent hit by a car, just mangled, or death, those things. And you take this and multiply that by thousands for this person. I mean, you're telling he didn't see his mother until he was, 5? And then he comes there, and then there's evidence about what her friend was doing to him and all those, this incredible. I just can't imagine being a child. I have to fend for myself. My sister have to steal food to eat or to be left alone and prostitution all around and all these things. You're telling me that would offend a jury to know that the brutal crime that he did, not matched, not balanced, but there's also a brutal story about his life too. And to make a decision that I don't put an ounce, not one paragraph of that before the jury, and you say that that's effective representation in a capital case? I know you represent the state, but that's your position, that that's effective representation?
Your Honor, you don't want to jeopardize your other defense. And in
The other
looking
defense
at,
was nothing. Whatever happened, it didn't matter. He was there. Whether he did these horrible things, that was a foregone conclusion. Nobody was going to go up there. I mean, a good lawyer's not going to say, I'm doing this because this is going to X out what he did. No, I'm only doing this to let you know that a fragile, fractured, brutalized child became the man you see now. That's what lawyering is.
Your Honor, at the end of the day, some crimes are so brutal, some crimes are so bad that the death penalty is the only just result, and that's what we have in this case.
That may be true, but don't you let the jury decide that? And so they can balance all of your very aggressive and proper aggravating evidence against that? Nobody is saying that per se death is not appropriate in the case. The point is the jury needs to have something before them to balance what an adversarial system is. That's the question.
Trial counsel didn't want that something to jeopardize his argument, and he reasonably concluded that it would.
Okay.
Because scalping a woman and cutting out her vagina, that you can't avoid that. You have to try and do something to mitigate that, and that was the heart of the case, just how brutal this was. It wasn't just a rape and a murder. It was a rape and the murder, and you leave her in the rotten woods after you scalp her head. The best argument to make was that some other guy did that piece. And if he offers the evidence of his traumatic childhood, he knows that it's coming in.
Can you just, I feel like I'm missing something really obvious. So if he puts up witnesses to testify to the fact that he was beaten as a child and that his sister was prostituted out and that he watched someone, his stepfather, I think it was, break his mother's jaw, those witnesses will also have to testify to who committed. I guess I'm not understanding how that brings out the evidence you're talking about which of these co-defendants committed the mutilation at the scene of the crime. How is the person who knows that his father beat him going to be able to testify to that? I'm not understanding.
So the primary witness here we're talking about is the sister.
I guess this is because we're bracketing the investigation. So we're assuming no thorough investigation has been conducted. They have not talked to any of the other people who know about this boy's childhood.
That's not
the only witness they could. Okay.
They talked to multiple family members, relatives, employers.
Well, it's not like the PCR counsel hired a magician. They hired an investigator who went out and promptly learned a boatload of information that trial counsel was unable to discover. So obviously the investigation was not that good. Whether it was, I don't want to prejudge whether it was constitutionally adequate, but we can agree, can't we, that the next investigator who went out discovered reams of information that the first investigator was unable to uncover?
And that would just reinforce that PCR counsel, their decision was even reasonable as well. But again, you have three prongs to this claim. You got to do trial counsel's deficient performance, prejudice by trial counsel, and then PCR counsel's investigation. And you just hit the nail on the head that was more than thorough what PCR counsel did. And they came to the same conclusion as trial counsel. They did not think.
Well, PCR counsel did not say that they came to a conclusion that this claim would not prevail. PCR counsel said they don't know why they didn't put it in the petition and why they decided instead to put in claims that were so weak that they had to be dropped before the PCR court could get their hands on it. And then two claims that, I don't want to cast judgment or anything, but these ineffective assistance of appellate counsel claims were not exactly bulletproof.
You're right. They were measured in their testimony. They said they couldn't remember why they dismissed the claim, but they supposed, and that was their actual words, that they supposed they got distracted. That was their testimony, but their actions speak louder than their words. And immediately after withdrawing this claim, they're taking intentional acts, notifying all the parties involved that they're invoking the attorney-client privilege, that because they're not alleging ineffective assistance of counsel anymore, trial counsel is not to share the files of the case to the state. Trial counsel is not supposed to speak with the state. And as a district court found, that was an intentional act. That is a strategic act. So what they testified to, that's one piece of information that you can consider, but their actions speak louder than the words. And the district court found that was an intentional act. And there's certainly nothing in the record that would warrant a finding that that was clear error on the district court.
I'm sorry, I've taken up so much of your time, and I apologize. I just have one very picky doctrinal question. I just wanted to remember to ask you. So picky. But why the district court granted summary judgment on the two Martinez claims? Is that right? Because, I mean, it's not as though it's not really summary judgment. There was a hearing, and the court made factual findings. So this is more like it's a totally picky little question, and is summary judgment, assuming that relief was properly denied, does summary judgment go along with that on the Martinez claims, given that there were fact findings by the court?
The Martinez hearing was to determine whether or not the exception applied, and it found that
right. No, I know.
I think summary judgment would be appropriate in that case, Your Honor.
But isn't summary judgment for when there are no disputes of fact? And here, in order to say this is a case involving no disputes of fact, it's a stupid, picky little question. I just am trying to figure out why this is a summary judgment case.
Well, if the claims weren't substantial, then summary judgment would be appropriate.
Okay.
And I see that my time is up. If the court has any other questions for me, I'll be happy to answer.
Thank you, Mr. Ross. Mr. Messina?
Thank you, Your Honor. I'll be brief. Just a few points I want to address. First, on the investigation, I think as the court's questions pointed out, really the only thing you need to do to see how inadequate this investigation was, all of which took place in the 3 weeks before the trial, is to contrast it with the investigation that Ms. Dean did later, which discovered so much more information. And Mr. Ross also referred to Dr. Rogers. There's no indication that Dr. Rogers had any of this information. We don't have his file, and he didn't remember what he had done. The only thing he did remember is that when he was in meetings with trial counsel, he felt like he wasn't really asked to speak, and he just remembered sort of being talked at and not being listened to much. So that's all we have on that. On the issue of the AIDS defense, Mr. Ross said the rug was pulled out on that. But of course, there's no reason at all why trial counsel couldn't have complied with Mr. Stokes' instructions about not putting in his AIDS diagnosis and still put in evidence about the abuse and deprivation he had suffered as a child long before he contracted that disease. As the court's questions rightly pointed out, nothing could possibly have surprised counsel about the jury's reaction to the facts of this crime. And of course, you could make that argument in every death penalty case. The death penalty has been limited to a narrow category of the most brutal and serious crimes. In every one of those cases, a lawyer could say, boy, the jury was really perturbed about the facts here. And that just can't be an excuse for not presenting any mitigating evidence. It's also clear that the jury here was scrutinizing this evidence carefully. Most of the evidence of the details of the crime Mr. Ross referred to came from the testimony of Norris Martin. Mr. Martin hadn't testified to any of those details until more than a year after the crime. He had given multiple statements to the police where he didn't mention them. So it's clear that the jury had questions about the truthfulness of that testimony. And ultimately, I think what's clear is that trial counsel just didn't understand how to use mitigating evidence in a case like this. Mr. Roth talks about how aggravated these facts were. Mitigating evidence is needed to counter that, to explain, so that the jury doesn't just see Mr. Stokes as a monster, so they can at least try to understand how he got there. What happened to him that made him capable of doing these things? And there was no way for the jury to have any insight into that. Mr. Ross also talked about, quite a bit actually, about some of this evidence being double-edged. And I really want to address that because, and I point the court, I think Mr. Weibel gave a helpful explanation of this at page 3301 of the Joint Appendix. There is no danger in South Carolina of opening the door. This comes up in some cases from other states. where if you put in evidence of the defendant's background or character, you're opening the door to additional evidence coming in on the other side. That's not true in South Carolina. The state was allowed to present whatever it wanted regarding Mr. Stokes' character and background, and it did, presented extensive evidence on those issues. What Mr. Ross primarily refers to is the fact that Sarah, Mr. Stokes' sister, in her interview, mentioned that that Sammy bullied Norris Martin when they were both children many years before this crime took place. First of all, there's no indication the prosecution was interested in asking about that. If they were, they could have asked Norris Martin. They could have asked Audrey Smith. They could have called Spencer Utze. This wasn't part of their presentation at all, so there's no reason to think they would have asked about it. And if they had, it would have been such a drop in the bucket. Again, this is vague testimony about the relationship between these two individuals when they were children. It wouldn't have shed any light on their respective roles in this crime that they committed many years later as adults. Dr. Garbarino, his credibility is really not the issue here. This is a red herring. He was offered as an example of the type of expert who could have been presented, and there's no dispute either about the facts of the mitigating evidence that he testified to or about the test that he applied that concluded that Mr. Stokes had a more traumatic childhood than 99.9% of everyone in the country. Those facts just aren't disputed. So just to wrap up, Your Honors, this really is an extraordinary case. We're not aware of any case where a death sentence was allowed to stand, where this type of mitigating evidence of childhood trauma was readily available, and the jury didn't hear any of it. I think, the prosecutor was able to tell the jury in closing that it had heard, quote, nothing about this man other than violence. The jury needs to hear more than that to make the moral judgment that it's charged with making in this kind of case. Thank you, Your Honors.
Thank you, Mr. Messina and Mr. Ross. We appreciate your argument. Can't come down and shake your hands. Please know that we appreciate your arguments. I hope that you will be safe and stay well. Thank you so much.
The Honorable Court will take a brief recess.
Ms. Bagalenti? Thank you.
All right. Mr. Roberts, you may proceed.
Thank you, Your Honor, and may it please the court. This is Dave Roberts for Appellant Lorenzo Pledger. Because the district court erred how it disposed of Mr. Pledger's claims, this court should reverse or at least vacate its judgment. Regarding the negligence claim, the district court should not have imported from West Virginia state law the provision requiring a plaintiff to provide an expert certificate simply to clear the pleading stage in this action. And regarding the indifference claim, the court should not have departed from the controlling summary judgment standard. But even before that, it should have given Mr. Pledger a fair chance to provide further evidence that prison medical staff knew about and disregarded a serious medical condition until he collapsed and required immediate surgery. I'll take those points in turn on the negligence claim. The state law provision here at issue speaks only to what a plaintiff must do to clear pleadings stage. It does not address what a plaintiff must do to prevail at trial. That simple reason provides the justification that the requirement does not apply here. I'll focus.
Mr. Roberts, on that point, it seems to me there's two ways, I guess, to make that argument. One is that you follow the recent, Sixth and Seventh Circuit opinions that kind of do the Shady Grove type analysis, or the other is you say those aren't met and it's procedural under Erie. Which one do you select?
The threshold point, and the one that's dispositive here, Your Honor, is the conflict issue that's adjudicated under Shady Grove, the Sixth and Seventh Circuit applications of which you reference. And the reason that there is a conflict here is multifold. I'll focus first, if I may, on the pleading rules and also those that pertain to expert disclosures.
Counsel, I'm sorry, just even before you start, I thought the holding of Shady Grove is there doesn't have to be a conflict. Why are you referring to this as a conflict analysis? I thought the whole point of Shady Grove was even if the two rules, even if a state and a federal rule are not in conflict, you could conform to both of them. If they both sort of govern the same area, then the federal rule displaces the state rule.
So Your Honor is absolutely correct that the threshold question is whether there is a conflict, and that's measured by what you see in Shady Grove, which is whether the federal rules answer the question in dispute. And they can do that either because they directly comply with the state rule or implicitly because they occupy the issue. And the reason that you see a conflict, this test is a straightforward application under the West Virginia provision, because here, if you take a look at the pleading stage, the question is, what must a medical negligence plaintiff do to clear the hurdles of Rule 12 and its state law analogs to state a claim and thereby avoid dismissal?
But Mr. Roberts, the certificate of merit isn't even filed. I mean, it's served, and maybe you're right. This is a hard area for me. I'll grant you. I've struggled with this a lot, and so I'm interested in hearing all sides of it. But it just seems odd to me that you would say the federal rules occupy this space when the state rule is cause of action specific. I'm not aware of any. I used to do tort law in a lot of different jurisdictions. I've never heard of federal rules of civil procedure dealing with cause of action type details like we have here. Maybe the one exception is 9B, But in general, that's not done. And I just would never expect, and don't see how anyone would expect, the federal rules of civil procedure to deal with something that relates so specifically to a state tort cause of action. And that's why Shady Grove seems kind of maybe applicable, but different.
Thank you, Your Honor. Let me turn to your first point there, which centered on the fact that the certificate is served rather than formally filed. This appears to be the way that the statute keeps the effect of its confidentiality so that it's not filed. The function here is what is relevant, and that's what you see by the practical application in Shady Grove itself. You see that in Gallivan, in the Sixth Circuit, and in the anti-SLAPP contexts in other circuits. The question is, what does a plaintiff have to do to prevent dismissal? And if you look at how this certificate requirement applies in the West Virginia State Court, it's clear that it's a gatekeeping device that is at the pleading stage. It is not only does it occur at the outset of litigation or discovery, but it's enforced by the state law analogs to Rule 12. There is a procedure to challenge its sufficiency, and if the certificate is not sufficient, then under the West Virginia analog to Rule 12, then a more definite statement can be ordered or the claim can be dismissed. What you have to look at is the practical application again, and you see this perhaps most clearly in the Boston Circuit. The question is whether there's an additional hurdle that a plaintiff must jump over to get to trial. I'm reading from 783 Federal 3rd 1334. And here you see that additional hurdle, and it's this procedural gatekeeping requirement. That same language, by the way, or similar language, I should say, you see in the majority portion of the Shady Grove decision itself, when it states that there's a conflict when state law imposes additional requirements on certain claims. That language from Shady Grove, Your Honor, I believe speaks to the second part of your question, which is how this is cause of action specific. And admittedly, you see many different birds here in state practice and how they apply to certain claims. But the entire purpose of the federal rules is to set out a uniform cause of action in similar circumstances that are not at issue here. And here you see this conflict most clearly when you contrast what Rule 9 addresses with the certificate, which demands particularized support and evidentiary support of that at the pleading stage, rather than simply stating factual allegations that make out a claim that's plausible on its face that would survive a Rule 12b dismissal of the federal court.
Can I ask just a question? If we adopt your position that the federal rules displace this state certificate requirement, then that would apply in diversity cases as well as FTCA cases, right? For Shady Grove or Hannah purposes, it doesn't matter, does it?
Yes, Your Honor. The rules would apply in the diversity context. Okay.
And so what do you want us to do with Davison, our somewhat old case affirming application of the pre-dispute arbitration statute in Maryland?
Sure, Your Honor. The court need not grapple with Davison or how it would be decided today. There was no conflict analysis. There was no question raised in that case of whether the federal rules did displace the state law requirement. I'd also point out in Davison, where you're talking about the Maryland pre-suit arbitration setting, you don't have the certificate sort of requirement here where you're demanding expert support at the outset of a case, where you are requiring all of that as a gatekeeping device at the very beginning of the case. So there could be difficult questions on different species of state medical malpractice laws, but those are for another day. And Davison, in particular, just doesn't answer the threshold question here, which is whether there's a conflict, and it need not be discussed farther by the court in adopting this position. With the panel's permission, I'd like to turn attention to the indifference claim, where really there are two key errors that took place, but they shared some crucial threshold points. First, all agreed that Mr. Pledger had a serious medical need. The only question, therefore, is the defendant's knowledge. And second, it's clear from this court's decisions that circumstantial evidence can be enough to survive summary judgment when it relates to the defendant's knowledge.
Counsel, if I could ask you a question before you get into the merits, and I know you want to get there, I'll be real quick. But if we agree with you on your criticisms of the Roseboro order, do we get into that issue?
The court need not resolve the sufficiency of the Roseboro notice, which relates, as the title indicates, to notice, because the court can simply hold, and I think the clear issue here is that Mr. Pledger simply never got a fair chance at discovery, regardless of deficiencies in his notice. And to his credit, Mr. Pledger did ask for this discovery multiple times and in multiple ways, and he cited the need to cross-examine witnesses in opposing summary judgment. He indicated to the court, to the magistrate, that discovery had not occurred, and the necessary discovery here was really plain to see. It centered on not only the medical records that were omitted from the summary judgment papers, but that the magistrate judge had identified the existence of and the relevance, but it also pertained to some discovery in some form on the defendants themselves to address the knowledge that they had, which is information that by definition was uniquely within the defendant's possession. So the error was here not simply to prohibit discovery, but even to provide any sort of reasoned explanation for that refusal, which we see nowhere in the record here. Turning briefly to the summary judgment question, the court so reaches that. The court here, the district court erred because a reasonable juror could find that the defendants knew about Mr. Pledger's worsening pain. They saw evidence of a mass in his abdomen that medical staff had palpated, and yet they did not follow through on their stated promises that are found again in the contemporaneous medical records to expedite an ultrasound scan and other referral care that had been recommended 2 months before, in this instance, Mr. Pledger's repeated complaints, and nearly 3 months before he collapsed in his cell block and had to be taken to outpatient care, and where just days later he received surgery. I would signal to the court just the key applications from this court's precedents that speak most directly. The Cinto case is instructive, where the court reversed the summary judgment award to a prison medical doctor who treated a diabetic patient because a juror could find, and I'm quoting here, that the doctor did not follow through with his plan to monitor and provide insulin to the inmate. The other precedents that I would refer your honors to are the Jehovah case. You see the Gordon case. All of these are recounted in the papers. And together, you see several themes that speak loudly through this court's precedents, that where there are promises to provide care that are put off and delayed and substituted with meaningless check-ins that don't provide adequate care to an inmate, that's not enough, and that is enough to raise the inference of the medical provider's indifference.
Counsel, just so I understand, so what do you want us to do on this claim? Do you want us to hold right now this goes to a jury, or do you want us to send it back for discovery?
The court has either option obviously available to it. I would submit that the ultimate disposition between those two doesn't result in a large difference on what needs to happen on remand, because there's been no discovery at all here. So regardless of whether the current very limited record would be enough to get Mr. Pledger past summary judgment and a trial, he deserves and he is entitled to get a fair shot to develop the very best evidence he can regarding the only issue that was at issue in summary judgment here.
So either way, there's going to be discovery, and people could remove for summary judgment after discovery if that seemed appropriate, right?
The government would, or the employees, I should say, would have the opportunity to remove if the district court allowed it, and if this court had not passed judgment on whether the current limited record would be enough to clear summary judgment.
Does counsel need to be appointed? I mean, if this is going back for discovery, is part of what you're asking for that counsel be appointed?
I'm not asking Your Honor in this position here to direct the appointment of counsel. I would submit that counsel in a case like this is very important, and part of that is because Mr. Pledger remains incarcerated. He lacks many of the usual tools that even an unincarcerated pro se plaintiff might have to develop his claims. And so whether that's what this court would do if it's so inclined, and it would be very helpful, or whether the district court decides that itself, counsel would be a very helpful and perhaps necessary addition to properly evaluate Mr. Pledger's claims.
All right. Thank you, Mr. Roberts.
Good morning, and may it please the court. My name is Max Nogay. I'm an assistant United States attorney for the Northern District of West Virginia. I represent the federal defendants, appellees in this matter. As to the FTCA case, this court should affirm the decision of the district court for two reasons. First, the West Virginia statute at issue, West Virginia Code section 55-7B6, is not displaced by a federal rule because its requirements must occur before a complaint is filed, not at the time or after a complaint is filed. Second, the West Virginia statute at issue vests certain substantive rights in the defendant healthcare providers, as this court has recognized the similar Maryland statute does. Every case cited or relied upon by the appellant analyzes a state statute or a rule that imposes requirements at the time a complaint is filed, not before a complaint is filed. And for that reason, this court should not follow the reasoning of those cases. The statute at issue is unique because it does not impose a pleading requirement. It does not affect the contents of the complaint itself. Instead, it imposes a pre-filing requirement, which requires the plaintiff in a medical negligence case to serve two papers onto a potential defendant. That would be a notice of claim, which would provide the theory of liability. Yes.
Counsel, if I could interrupt you, just for the sake of discussion, assume that this doesn't fit neatly into the Gallivan Shady Grove type paradigm, and we're looking at the hard stuff, whether it's Erie or not, and what is basically required by this statute is information that is not in addition to the ultimate burden of proof that must be shown to prevail on medical malpractice. So it doesn't impose an additional heightened burden. It's a filing type act. I get the point that it also includes an affidavit that's got substantive information in it, but I'm having real trouble under Walker and these cases of figuring out if you're in the Erie world, whether it's procedural or substantive. How do you deal with the fact that it really doesn't give the cause of action more life, or I guess it gives it less life, potentially procedurally, but it doesn't really add anything. It just moves it up in time.
Well, Judge Quattlebaum, if we're looking at just a substantive versus a procedural analysis, I think we need to look beyond simply what is being served on the defendant healthcare providers. When a doctor or a physician's assistant receives notice when it's served upon them, they have the option to elect mediation, and they have to elect that within 30 days of service of the notice of claim and a certificate of merit. So certainly that is a substantive right that is being vested in the defendant healthcare providers. And as I will get to this, the Maryland statute, as Judge Harris alluded to, it is a pre-dispute arbitration clause where the parties must engage in arbitration unless they both agree to waive arbitration. And there's an additional substantive aspect upon receipt of the certificate of merit. Under West Virginia case law, if the defendant believes that there is a defect or that the certificate is not clear enough, they can then request or demand from the plaintiff to then revise or redraft the certificate to compose a more definitive statement. And there is no controlling authority, as this court is aware, on this matter in this circuit. So appellant relies upon multiple cases from the 6th and 7th circuits that address statutes that are totally distinguishable from the West Virginia statute at issue. Gallivan v. United States is a 6th Circuit decision in 2019, and the 6th Circuit analyzed, it was styled as an Ohio Civil Rule 10D2, and it requires plaintiffs to attach an affidavit of merit, which is like the certificate of merit here, to a complaint. And the court in Gallivan found that under a Shady Grove analysis, Federal Rules 8, 9, and 12 displaced that requirement because it affected the contents of the complaint itself. And the court there applied a straightforward Shady Grove analysis and made that decision. And the 7th Circuit in Young v. United States, the court analyzed an Illinois statute, which again requires plaintiffs to attach an affidavit of merit to the complaint. And the Young decision did not go quite as far as Gallivan. It still held that at the summary judgment stage, the defendants can then invoke that requirement and the case can be disposed of at summary judgment. The appellant also cites to Shields v. United States, which is a 2020 District of Connecticut case. And the court there analyzed the Connecticut statute, which again requires the plaintiffs to attach a detailed written opinion to the complaint. And also, when you sign a complaint, that in effect is an explicit good faith certification. And all of those cases, as I've explained, they deal with the actual pleading itself with the complaint, whether it affects the contents of it or whether it affects the attachments to it. None of those statutes and none of the cases relied upon by the appellant in this matter address what is to occur prior to a complaint being filed. And if we're looking at a Shady Grove analysis, it would be the government's position that that this case can be disposed of at the first step, and that is that it cannot be disposed of at the first step because there is not a federal rule that is sufficiently broad to control what occurs prior to a complaint being filed. And if we cannot answer that question, we then move on to whether the rule is substantive or procedural, and it would again be our position that there are certain substantive rights that are being vested in the defendant healthcare providers, that they have the right to engage in mediation, they have the right to object to the certificate of merit and request that it be amended or supplemented or be drafted more clearly. And the government filed a supplemental authorities letter in reference to Fourth Circuit cases in which the Maryland statute, the arbitration statute, was not at the forefront. Those cases admittedly were equitable tolling cases, but the court did engage in some sort of analysis into the Maryland statutes. And that case would be Rapley v. United States. It's a 2016 Fourth Circuit case. And the focus there was on whether or not filing a claim with the state agency in Maryland began a civil action. The court held that it did not. However, the court wrote that the plaintiff must work simultaneously to satisfy state law requirements as well as federal requirements in filing these cases, because the FTCA is a waiver of sovereign immunity. However, it holds the United States liable to the same extent and to the same manner as a citizen of that state would be held liable. And the court there, it said that under Maryland law, the plaintiff must submit a medical malpractice claim to the state agency. And I believe the counsel for the appellant misspoke. Under the Maryland statute, prior to a civil action being filed, the plaintiff must also file a expert report with the state agency within 90 days of filing a claim with the agency. And at that point, then the parties can either engage in arbitration or they can waive arbitration and then proceed to a civil action. And the government also cited in its supplemental authorities letter, Lucas v. United States, which is an unpublished Fourth Circuit 2016 opinion. And there the court was dealing with, again, equitable tolling and whether the filing of a claim with the Maryland agency began a civil action. But it also wrote that a state unquestionably has the prerogative to place whatever requirements it chooses on tort causes of action. And Congress intended the FTCA plaintiffs to comply with those state requirements as well as the federal requirements. And there is one Northern District of West Virginia district court case. It's a 2004 case, Stanley v. United States, and the court, relying upon Davison, it simply held that the pre-filing certificate of merit statute is substantive. And there it conducted an Erie analysis, and it held that it would be outcome determinative because it would alter the character of the litigation if the suit was brought in federal court as opposed to in state court. And while this may not be pertinent here, that it could also encourage forum shopping. The appellant makes the argument that the West Virginia statute is displaced by 3 federal rules, the first being Federal Rule of Civil Procedure number 8, which controls the contents of a complaint. And that rule simply states that plaintiffs must have a short, plain jurisdictional statement, and then it's a notice pleading rule. It does not control what must be done prior to a complaint being filed. So that rule is not implicated. Yes,
Counsel, I'm just trying to track your argument with your brief. Did you make a Shady Grove argument in your brief that there was no displacement under the federal rules here? Did you? No. Okay.
The brief was primarily utilizing an Erie analysis. Right. My argument would be in rebuttal to appellant's argument today. However, Erie is still part of the Shady Grove analysis. And the second rule that the appellant claims displaces the pre-filing requirement would be Federal Rule of Civil Procedure number 9, which deals with heightened pleading cases such as fraud or mistake. It's not, again, applicable because those control the contents of the complaint. The West Virginia statute does not deal with what is in the complaint. And
so, counsel, I have a question. It may be not for you or your colleague. I have a question about the Bivens case. Is that appropriate for you, or have y'all divided that separately?
Yes, Judge, I can address the Bivens case.
So help me on the issue of both the notice and the discovery issue. The notice here doesn't say anything about filing, responsive affidavits or anything. It's actually, seems different than most of these I've seen before. And then, respond to your colleague's argument that, maybe not officially or real clearly, but there's allusions to discovery that looks like they're saying we need some discovery. Those are the two issues I'd like for you to hear from on the Bivens claim.
Well, Judge, I will address the second issue you raised there first, because I think it's dispositive of the entire question. Upon filing the motion to dismiss, or in the alternative, motion for summary judgment as to the Bivens case, the government attached over 600 pages of the plaintiff's medical records, and those records were made available to the plaintiff at that time. And also, it is BOP's procedure whenever an incarcerated individual wants to review their medical records, in this case for purposes of litigation, they have that right to review the medical records with a caseworker. And the court is continually putting the plaintiff on notice. We'll go back to the certificate of merit issue. The court is going above and beyond to notify the plaintiff what it must do to comply with its requirements.
Well, that's my problem. That's my problem. We got to decide. I don't want to make a decision, but as I actually got the Roseboro order, and to be honest with you, I got some from other district courts around to compare them, and this one doesn't do a lot that other district court orders do in Roseboro notices. And so you may be right, they may have gotten in effect everything they would have gotten. Maybe that's your point, that if you attach everything, I'm not sure what'll happen at the end of the day, if there'll be anything more or less through discovery. But my concern is there wasn't a notice to a pro se litigant that they had to file things like affidavits, responsive affidavits or other things, like there is in some other notices. And so that's my concern. I don't know if it'll make any difference at the end of the day.
Judge Gregory, I see that I'm out of time. May I answer the question?
Yes, you may.
Judge, I would take the position that it would not make any difference. The Roseboro notice, while we may agree that it doesn't fully state what a plaintiff in this case must do to survive summary judgment, it does allude to and state the certain rules. And the plaintiff had the ability to go to the law library to take a look at the rules of civil procedure and read for himself. However, in these Bivens cases, there's a disincentive against putting federal employees, such as prison officials, through grueling discovery and depositions and potentially putting their personal liability at risk here. And in this case, the medical records control the entire case. And it would be our position that would dispose of plaintiff's Bivens case.
Because the question I have, and when you say the medical records, were these his complete medical records? There are no other medical records?
The records that were attached to the motion were the records that were in the possession of the BOP. And those would be the relevant records between 2014 and 2016 at the time that Mr. Pledger was incarcerated in FCI Gilmer. Okay, so it just sort of seems to me that the thing they don't answer, the fundamental question, I think, under our case law is you have, the government's own doctors prescribing this treatment for the plaintiff. He should get a sonogram, he should get a GI consult, and nothing happens for 2 or 3 months as he continues to report with increasingly severe symptoms and pain. And there's nothing to explain why not. And so that just seems like it's sort of a central question. And the answer to that question, why did he not get the treatment that the doctors thought he should get, isn't going to be answered by the medical records, or is it? Is the answer to that question somewhere in the medical records? Well, Judge, I would answer that question in two parts. It's BOP procedure that when an inmate needs to be sent outside of prison for a consult, that it has to go through certain approvals. And sometimes that approval process may take in upwards of 6 months. In this particular case, the appellant underwent a colonoscopy on May 19th of 2015, and he's reporting these stomach pains less than 1 month later. And he was not being denied medical care. However, that colonoscopy did not reveal any glaring issues or blockages for the prison officials to say, this is a serious issue, we need to send him back out for another colonoscopy. There's continual reference to the fact that there was a recent procedure done, it revealed no problems, and then the appellant at least on average, at least once a week, was physically examined by the health services staff. His stomach was palpated, his vitals were taken, he was physically examined. So we would, I guess, close this argument with the fact that this is a disagreement in what care or treatment was provided to the plaintiff, not that it was a deviation from his constitutional rights and a deliberate, indifferent decision to then deprive him of certain medical care that he required.
All right. Thank you, Mr. Nogue. Mr. Roberts? I'm sorry. Ms. Bagliani?
Thank you, Your Honor. Christine Baglianti on behalf of St. Joseph's Hospital. If it please the court, I want to make it clear in the beginning that the plaintiff's FTCA claim is not applicable to Mr. Pledger's claims against St. Joseph Hospital, which is a private entity. And Mr. Pledger can't seriously challenge the district court's ruling that a Bivens complaint cannot be maintained against St. Joseph's Hospital. So my concern and my focus really is on the application of the federal rules of civil procedure to a medical malpractice claim against the West Virginia private entity in federal court exercising diversity or supplemental jurisdiction. The West Virginia pre-suit notice requirements set forth in West Virginia Code 5576 clearly are not procedural. They are substantive and jurisdictional. In syllabus point 2 of State Ex Rel Prime Care versus Faircloth, a 2019 decision, our Supreme Court determined that these pre-suit notice requirements, Judge Keeley in the Northern District of West Virginia analyzed these same pre-suit notice requirements and determined them to be substantive, not just procedural. And
Counsel, it's Judge Harris. I'm sorry. I will better understand your argument. If you will just situate it for me, why is the hospital still in this case? What claim is still pending against the hospital? I thought the hospital was dismissed as an inappropriate defendant under Bivens, and I don't understand that to be on appeal, but is it?
I believe it is on appeal, Your Honor, because in Mr. Pledger's complaint, he lumps together all the defendants claiming that the dismissal of the medical malpractice claim was inappropriate because of the alleged conflict between the pre-suit notice requirements and the federal rules of civil procedure.
Okay, but just so if we agree with you and with the district court and the magistrate that a hospital is not an appropriate defendant under Bivens, that's it, right, as to the hospital?
I think it is, unless, as Mr. Pledger's counsel urges you to find, that there is still some survival of a common law malpractice claim.
Okay, all right.
Yes. With respect to Judge Keeley's decision in the Stanley case, the Northern and Southern District West Virginia courts followed that reasoning between 2004 and 2019. And then after the Prime Care decision in 2019 came out of our West Virginia Supreme Court, that has been adopted by the Southern and the Northern District courts in the Carter and Orlando cases. As Mr. Nogue said, The decisions made in Gallivan and Young were based on the assumption and frankly the agreement by the state courts that those pre-suit requirements were procedural. But we've gone far beyond that in West Virginia, and our pre-suit notice requirements give substantive rights to the healthcare providers who may be defendants. The substantive right to notice and the substantive right to demand pre-suit mediation. And that's different than either of the statutes considered in Gallivan or in Young. The pre-suit notice requirements are just that. They're pre-suit. They don't change anything about the nature of the complaint that must be filed, the allegations that must be included in the complaint, and frankly, the notice of claim and certificate of merit are not even supposed to be filed in court. They're supposed to be confidential. So I think that that makes it clear that they don't change anything about the pleading. Instead, they give the healthcare provider defendants a defense to the complaint under 12b1, which is lack of subject matter jurisdiction. I think it's also important to point out here with respect to my client in particular, that the district court very carefully pointed out to Mr. Pledger that the certificate of merit requirement was applicable to his medical malpractice claim and gave him additional 60 days to come up with certificate of merit after Mr. Pledger had requested that, but Mr. Pledger did not follow through with it. So the district court, I believe, bent over backwards to give Mr. Pledger both notice of the requirements and then an opportunity to meet the requirements. But he did not, as I said, follow through. And even if Mr. Pledger thought that those pre-suit notice requirements had been satisfied through the administrative claims that preceded his Federal Tort Claim Act, my client was not a part of that. So based on all of this, we ask that the court affirm the lower court's ruling that the Bivens action is not applicable to St. Joseph's Hospital, and also to find that the pre-suit notice requirements should apply in federal court because they are jurisdictional and substantive, not procedural. Thank you.
Thank you very much, Ms. Baglianti. Mr. Roberts, you have some time reserved.
Thank you, Your Honor. A few points, and I'd like to begin by pointing out the striking contrast that we see most clearly with the government's position. You see, in the context of the negligence claim, the government attempting to hold Mr. Pledger to these various procedural requirements that apply in state courts in West Virginia. On the other hand, though, when you turn to the indifference claim, you see the government really attempting to justify the courts and its own departure from the process that Mr. Pledger was entitled to before the court reached summary judgment and before it addressed the merits of that action. When you look to the negligence claim in particular,
but Mr. Counsel, Mr. Roberts, aren't you doing the same thing? I mean, you're saying don't worry about the procedures in the tort case, but you do worry about them in the Bivens case. I mean, y'all are both kind of, because it behooves you, stressing procedure in one and not the other.
Your Honor, respectfully, I would suggest that we are focusing on procedure just as much regarding the claim. And here, the procedures are spelled out in the federal rules of civil procedure. I know that my friends on the other side make a point about the timing of the certificate and that it's served rather than filed. But the dispositive question and the practical application of the conflict test that we see in Shady Grove, that we see in Abbas, that we see in Gallivan, that we see in the Clock decision from the Fifth Circuit, is all going toward the same question. What does the claimant need to do to advance to the next stage of litigation? When you're in West Virginia Supreme State Court, you must file, or you must serve rather, the certificate before you can advance beyond the pleadings. In federal court, there's no requirement to attach any material to a complaint. The federal rules speak impliedly, granted, to whether attachments are necessary at all. So the government and St. Joseph's do not escape the presence of a conflict merely by talking about the precise mechanism by which the state accomplishes this goal. I turn briefly to the question of whether the certificate confers a substantive right, and I would respectfully disagree with my friends because they refer only to rights to a process, right? In one instance, notes rights to mediation, but those are rights to process. They are not elements of claims. They are not defenses to action. They are not in any way what we conventionally in the unguided murky waters of theory or in other contexts refer to as substantive. I would just briefly address, if I may, the question of what happens if we apply the unguided in theory inquiry. And I would respectfully answer that even under that more challenging test, this is not a substantive requirement. The certificate requirement does not change whether expert support is needed for a plaintiff to prevail at trial. It only changes the timing. That's a classic procedural question, and it's not substantive. Because it does not change the need for expert, it's unclear, and I would submit speculative to say that forum shopping or other problems result, even in the first instance. Finally, if I could just address the Bivens claim briefly, I would point out that there was not an opportunity for Mr. Pledger to review all of the records at issue. That's because not all of the records at issue were in BOP's custody. There were records, and these are the ones that the magistrate judge refers to, that were not, and there's no indication of records that Pledger ever had access to. Regarding the sufficiency of notice, I think Your Honor is perceptive in gleaning the problems with the Roseboro notice, where we're not asking for a roadmap, but we are asking at least that the court fully and accurately state the only two rules at issue, because the problem with misstating the rules, and omitting some of them, which is the problem with the Roseboro notice here, is that it leads pro se like Mr. Pledger astray. I see that my time has expired.
Before you go, I'm sorry. Can you just tell me what is the status of the hospital in this litigation? I don't understand.
Sure. So, it generally comports with what my friend on the other side described, which is that the issue of whether the hospital is a proper Bivens defendant is not a question that's been briefed on appeal here. But you do still need to assess how do you characterize whatever the claim that was brought, whether or not it fits into Bivens. Here, and this is recited, I believe, on page 18 and 5 in our brief, where we explain that the district court had not passed judgment on whether Mr. Pledger's claim is actually simply one for medical negligence against the hospital. And I would submit that that decision should be left for any remand that the court may order.
Okay.
Unless there are further questions, I thank the court for its attention today.
Thank you, Mr. Roberts. I note that you're court appointed, and I just want to say on behalf of the court, we appreciate you and other lawyers who take cases on assignment. It's very important to the court, and we appreciate that very much. We also note able representation of the Attorney General by Mr. Nogan and representation of St. Joseph Hospital by Ms. Baglienti. Thank you so much. We can't come down and greet you all, but know that we appreciate so much your being here, your audience, help us decide these issues. That you would stay well. Thank you so much.
Thank you, Your Honor. My pleasure.
Thank you, judges.
Thank you.
You're
Judge Gregory?
Yes, ma'am. All right, you all ready? Mr. Bollinger, we'll hear from you.
Thank you, Your Honor. May it please the court. My name is Scott Ballinger. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law. And it's my pleasure to introduce Mr. William McKinsey and Mr. Joshua Short, who will be presenting argument today for Mr. Wright. Mr. McKinsey is going to handle the opening argument.
All right, thank you so much. Welcome, Cavaliers. Glad to have you with us. And Ms. McKinsey, you may proceed. I'm sorry.
Thank you. Thank you, Your Honor. Sorry. May it please the court, I also ask, if I may, to reserve 5 minutes of rebuttal by co-counsel. Mark Wright has spent the last 9 years in prison for a crime he was never charged with, in which the jury could not lawfully consider because his attorney did not bother to investigate the prosecutor's erroneous claim that grand larceny was a lesser included offense for the charged crime of robbery. As the prosecutor from the South Carolina AG's office said in the second case before this panel, the first question in any Strickland analysis is whether the defense attorney conducted an appropriate investigation. The Sixth Amendment right to competent representation cannot be satisfied by an attorney who fails to do the legal research necessary to support informed legal judgment.
Mr. McKinsey?
Yeah.
Are you going to have to keep your voice elevated as much as possible because you're trailing off? So speak a little louder than you ordinarily would because you're trailing off.
Yes, Your Honor, will do.
There you are. There you are. I'm sorry.
Yeah, maybe step forward. Come
there you are.
Yeah.
A defendant's Sixth Amendment right to competent representation cannot be satisfied by an attorney who fails to do the legal research necessary to support informed legal judgments, unless for some reason the circumstances make failure to do that research professionally reasonable. In Hinton v. Alabama, the United States Supreme Court held that unjustified ignorance of the law is itself a quintessential example of unreasonable performance. And in Wiggins, the court held that standard to have been clearly applicable for EDPA purposes since Strickland itself. But this is not the standard that the Virginia Supreme Court applied. The Virginia Supreme Court did not even attempt to justify counsel's failure to look into potential lesser included instructions. And that's because no justification is possible. Now, of course, if an uninformed attorney lucked in to a position that could not possibly have prejudiced the client, there wouldn't ultimately be relief. The defendant wouldn't ultimately be entitled to relief. But that's a separate prejudice question. And it's analyzed under a much less deferential standard. The question is whether counsel's failure to look into the law could have led to a reasonable likelihood of a different result. And the Virginia Supreme Court never actually got to the prejudice inquiry. Instead, the Virginia Supreme Court told Mr. Wright that unless he could show that no competent counsel could have made the same decision that his attorney made in this case, he had no claim. And that's clearly not the federal rule. The no competent counsel standard articulates the maximally deferential standard. You can't get more deferential than to ask whether any fully informed attorney might have made the same decision. And the cases that the Virginia Supreme Court cites for the no competent counsel standard clearly don't apply in this context. Those cases stand for the well-established principle that in the face of a silent record, an attorney is presumed to have engaged in informed decision-making. But in a case such as this one, where we have evidence, and here we have a lower court factual finding that the attorney acted in ignorance of the law, then the question becomes whether the attorney's failure to do legal research was itself professionally excusable. Yes, Judge.
So, Mr. Ballinger, let me ask a question kind of this way. I mean, I'm pretty familiar with those failure to investigate cases and how that relates to knowing the law. This issue, which he clearly didn't know about, came in the context of a trial, in the dynamic trial. So it feels a little bit less like a failure to investigate and just a failure to know an issue that was presented in the course of a trial, where you don't always get to say, hey, let me stop our trial and go research some stuff. Maybe you should. Maybe that's the point. But does that matter at all? And does the position you're arguing mean that anytime a lawyer in the middle of a trial makes a decision on a mistaken view of the law that he nevertheless feels is beneficial, that's automatically ineffective assistance?
No, Your Honor, not automatically. Under Wiggins, the question becomes whether the attorney's ignorance is itself professionally excusable. And here, what Wright's trial counsel did is indefensible. He made a mistake about a fundamental point of law for his client, how much time the client could spend in prison, what crimes the jury could and could not be instructed on. You can't get to a more fundamental point of law than that question. And so under Hinton, we have here a quintessential example of unreasonable performance. Now, the Virginia Supreme Court did not address the prejudice prong, so it's reviewed de novo by this court. And under Strickland, the prejudice inquiry, of course, is whether there is a reasonable likelihood of a different result, but for counsel's failure to investigate. And as Judge Ellis said in the remarkably similar Spivey case, a criminal defendant is obviously prejudiced by an error that causes the jury to consider a verdict in a lengthy sentence that should never have been offered in the first place. We have the odd situation here where we can be certain of a different outcome. If Mark Wright's attorney had the wherewithal to object to the grand larceny instruction, his objection would have been sustained. The instruction was illegal under Virginia law. Now, there are several arguments from the Commonwealth that I'd like to take some time to address. First, the Commonwealth argues that were it not for the grand larceny instruction, the jury wanting to convict Mark Wright of something would have just convicted him of the robbery charge. We have two responses to that. First, the jury did not condition its robbery acquittal on a grand larceny conviction. The jury found that the elements of robbery had not been met. And Strickland requires us to assume that the jury did its job. And furthermore,
but counsel, let me stop you there. I think that's fair, but isn't the issue not that what the jury did, but what the lawyer was thinking about and what the risks were pre-verdict? I mean, I get you now that there's a acquittal on robbery. We know that fact. It'd be one thing. But when you don't know what the jury is going to do on robbery, I know you got petty larceny, but you think, hey, they're not going to give them just a slap on the wrist with that. I'm worried about the other. That's where the lawyer was, and so. Is our inquiry at that point, or does our inquiry have to be informed by what the jury subsequently did? Because then it's easy, right? You know for sure what you're going to do.
I think it's important, Your Honor, to separate the prejudice and the deficiency inquiries. And your concern gets at the deficiency question. When analyzing whether counsel's conduct was professionally reasonable, we have to look at his conduct based on what he knew at the time. And you're right, he didn't know what the jury would do. But the deficiency here was counsel's failure to know the law, to know a fundamental point of law. And again, in Hinton, that is clearly a quintessential example of unreasonable performance. Now, having established deficiency, Strickland moves on to the prejudice inquiry. And we have a separate inquiry because we want to We want to ensure that a claimant only gets relief when they were actually prejudiced by their lawyer's incompetence. But the prejudice question is just much less differential. It's whether there's any reasonable likelihood of a different result. And the possibility that the jury might have convicted of robbery had it not had the grand larceny alternative just doesn't cut it. The prejudice question is not whether creative prosecutors can come up with a counterfactual in which Mark Wright still ends up in jail for grand larceny. The prejudice question is whether Mark Wright can show any reasonable likelihood of a different result. Now, the Commonwealth also claims that Mark Wright wasn't prejudiced because the prosecutor could simply have moved to amend the indictment. And we also have two responses to that. First, the likelihood of the same result does not negate, the possibility of the same result does not negate a reasonable likelihood of a different result. So here, the prosecution's claim, again, is premised on the idea that so long as creative prosecutors can come up with a counterfactual in which Mark Wright ends up in the same place, that he can't show prejudice. But that's just not the question. And besides, the prosecutor testified in this case that such motions to amend the indictment are unusual. There's no reason to think that he would have brought such a motion, and there's even less reason to think that the court would have accepted the motion. Why in the world would a busy trial judge, after the close of the evidence, allow the prosecutor to amend the indictment just to include a charge that he had already decided not to include? It is at the very least reasonably likely that the judge would have denied the motion and instructed the prosecutor to carry on with the crimes he had actually chosen to charge and any proper lesser included offenses of those crimes. At the end of the day, the Commonwealth's argument comes down to the claim that Mark Wright has waived mention of petite larceny. But the petite larceny instruction, or the possibility of the petite larceny instruction, really only comes into this case by way of a response. It's not a new claim, and it's not even a new argument. It's a rebuttal to the Virginia Supreme Court's erroneous application of the no competent counsel standard. Mark Wright is simply saying that even if the no competent counsel standard was applicable to failure to investigate cases, which it's not under clearly established law, Mark Wright should still win this case because no fully informed attorney would have asked for or accepted a lesser included instruction for grand larceny just to offer the jury a less serious alternative when he could have gotten the same thing without exposing his client to an additional 20 years in prison. And as the court said in Vincent v. True, even under the rigorous AEDPA standard, we don't have to credit an attorney's decisions if they made no sense whatsoever. If you have any more questions, I'd be happy to answer them. But otherwise, I thank you for your time.
Thank you so much. Ms. Johnson?
Good morning, and may it please the court, Victoria Johnson on behalf of the Director of the Virginia Department of Corrections. This court should deny Mr. Wright habeas relief in this case because he has failed to establish that the Virginia Supreme Court's denial of his ineffective assistance of counsel claim was based on an unreasonable determination of the facts or an unreasonable or contrary determination of an application of federal law. In order to meet this standard, Mr. Wright must show that despite the wide latitude the Virginia Supreme Court has in applying the general Strickland standard, it still managed to blunder so completely that no fair-minded jurist can agree with denial of relief. Additionally, Mr. Wright has not established Strickland prejudice. Turning to the AEDPA standard under 2254D1, I think that is where this, that's obviously the primary question before this court. Mr. Wright has argued that the Supreme Court of Virginia applied a higher standard than that allowed by Strickland for deficient performance because the Virginia Supreme Court used the phrase no competent counsel. I submit that that's an incorrect and mistaken reading of the law. The no competent counsel phrase has been used pretty consistently in both state and federal courts as a convenient short.
Counsel, sure, but like the context, right, the phrase itself appears frequently. But it seems, and do you agree with this reading of what the Virginia Supreme Court held? It seemed to me that what they held was whether or not his performance, whether or not this lawyer was unreasonably uninformed as to the law, the question for deficiency is whether some other hypothetical informed counsel might have made the same decision not to object to instruction number 10. And because he can't show that this other hypothetical informed counsel would have been unreasonable in failing to object, then he can't prevail. I mean, that's how I read the Virginia Supreme Court decision. Do you disagree?
No, I don't disagree, but that is not...
Okay, well, how is that right? How is that right? I mean, it seems that I don't understand how to mesh that with the Supreme Court decisions saying that, if the investigation or that a strategic judgment is only as reasonable as the information that goes into it. And so if a counsel is not informed, he's not in a position to make a strategic judgment. How do we mesh those two things?
I think I have two answers to your question, and I'll start this way. The Strickland standard for deficient performance is whether an attorney's conduct fell below a wide range of acceptable competent performance. And I think that the hypothetical no competent attorney standard that has been kind of used throughout various cases is a shorthand for that. It's whether an attorney's performance is objectively reasonable.
So let me make, I need to, there are two different ways you could think about this case or argue this case. You could say it was reasonable, and this is sort of picking up on my colleague Judge Quattlebaum's question, it was reasonable for this lawyer not to know that grand larceny was not a lesser included offense. Some other competent counsel might not have known that too. I didn't understand the Virginia Supreme Court to be saying that. I thought they were saying, or that the Virginia Supreme Court was saying, whether or not it was reasonable for him not to know it doesn't matter, because even if he had known it, he still might not have objected. It is possible to imagine a competent counsel who knew full well that instruction 10 was wrong and still didn't object because that's what the Virginia Supreme Court said, because he wanted the jury to have the alternative of a lesser included offense. And so some other fully informed counsel might have made the same decision, and therefore he doesn't prevail under Strickland. So those are two different things, right?
I think I see them as two sides of the same coin, Your Honor, and maybe I'm just not picking up on the court's distinction here. I think that there, like the court said, I think that there's a couple of different ways to look at the case. I think that you can look at it as, and I think that this is probably how the Supreme Court of Virginia applied the general rule in Strickland, and I submit it was not unreasonable within the meaning of 2254D, that here, even if a fully informed attorney knew that grand larceny from the person was not a lesser included offense, there are good strategic reasons for that fully informed attorney to not object to the jury instruction. Yes.
So, counsel, let me stop you on there, I think which of these two options to me is pretty important, because in that second scenario, you're suggesting that a lawyer, the court is about to make a charge that the lawyer knows is contrary to the law. right? I mean, under that hypothetical, the lawyer knows that grand jury is not a lesser known offense and knows that the judge is about to do something that's legal error. And are you saying it's reasonable? I mean, does he have an obligation under the rules of professional responsibility to point that out? And is it unreasonable to kind of ignore that and go forward? That to me seems like a pretty big problem with the second issue. It's it's better for his client, maybe, or arguably, but it's contrary to his ethical responsibilities. The first one, Judge Harris makes a good point. It may or may not be the court's reading. I think you could look at that, and that's an issue. But it seems to me the first one may have some stuff you don't like in it, but may be the way you have to go.
Well, Your Honor, I think that actually highlights a real big picture concern in this case. And that is whether an attorney, a defense attorney, has an obligation, a constitutional obligation, to object when the Commonwealth, when the government makes a mistake that can inure to his client's benefit. And I think that the ethical obligation may actually cut the different way for a defense attorney. Okay. Because for instance,
you want to stick, and I don't blame you, because I think this is what the Virginia Supreme Court held too. You just want to stick with the theory is that because even if his failure to object was a legal error, it's still not deficient, because he can't show that a competent and informed counsel would not have taken the same action that his counsel did take. Right? I mean, this seems clearly what the Virginia Supreme Court is saying. Whether or not he had any idea what he was doing doesn't matter, because, as you say, a fully informed counsel might well have chosen to let this charge go to the jury. And I guess I'm having trouble meshing that with other cases on this. Let me ask you this hypothetical. What if counsel, instead of being sort of metaphorically asleep at the wheel, had been literally asleep during the colloquy over Instruction 10? And so he didn't object. It seems to me the Virginia Supreme Court would then ask, okay, that was bad, but could some other alternative hypothetical awake lawyer have made the same decision? And because that awake lawyer might have made the same decision, there's no deficient performance.
I think there's case law that is directly on point. I don't have it at my fingertips at the moment.
Yes, and it goes the other way, which is why I'm raising it.
And
right.
I think that
the case law goes the way your colleague was talking about it. That's a prejudice question. We absolutely ask that question for prejudice. But nobody says just because a hypothetical awake lawyer might have decided not to object, that's not deficient performance. And so I don't see how you, whereas the Virginia Supreme Court clearly seems to be asking that question. Even if this lawyer didn't object because he was ignorant of the law, doesn't matter, because even if he had known the law, he would have made the same decision.
And that's exactly what counsel testified to at the evidentiary hearing.
I know, but if he had been asleep and had come to an evidentiary hearing and said, look, it doesn't matter, even if I'd been awake, I wouldn't have objected. I really wanted the jury to have a drop-down option. You know, that's not the way the cases analyze this question. If you're not in a position to know that you are being called on to make a strategic judgment, it doesn't count as a strategic judgment. This lawyer, he had no idea that he faced a strategic choice because he didn't know he had any grounds to object to this instruction.
I think that he didn't know that he had a grounds to legally object to the instruction. But I don't think that means that he was in full not making a strategic decision, because he was making a strategic decision based on what defense he wanted to forward at that moment. And that was, do I want to do an all or nothing on robbery, or do I want to have the option of a drop down? And my colleagues on the other side have argued that, well, he could have gotten petty larceny instead and could have.
But even before you get to petty larceny, he didn't think he had a choice as to whether he wanted to go all or nothing or take the drop down. Because as I understand it, under Virginia law, if grand larceny of the person is a lesser included offense, The state gets that instruction. He has no grounds to object. So he didn't have a choice. The state has made the choice for him. There's going to be a drop down.
And what he testified to was that he wanted that drop down because at that point, the Commonwealth had shown a pretty compelling narrative of the events of the day that had gone from a shoplifting event to a confrontation, a daytime confrontation in a parking lot, to a standoff that lasted for a couple of hours. Eventually, you know, some of the more serious charges, the assault on the police officer, the obstruction wasn't that serious, but the obstruction, the malicious wounding by means of chemical, all of that dropped out on appeal based on arguments that this attorney made. But the attorney didn't know that that was going to happen. The attorney didn't know how the jury was going to go on the robbery charge. 2 motions to strike, or I think in federal parlance, it's motion for judgment of acquittal, had been denied. So the evidence had been determined to be legally sufficient to go forward on robbery. At that point, he needed to know whether he was going to go all or nothing on robbery or whether he'd get a drop down. Now, I've argued that the petit larceny option was something that wasn't pled in state court and is defaulted. But I submit that the petit larceny option wouldn't have worked for him anyway, because under Virginia law, the lesser included has to be supported by more than a scintilla of evidence. And here there wasn't more than a scintilla of evidence. If there was a second taking, it was from the person for an item that was valued for more than $5. And so that petit larceny instruction wouldn't have gotten him very far. And I think to kind of revisit where the court's questioning was earlier, I think that the Virginia Supreme Court's application of Strickland in this case was within the range, because the Supreme Court of the United States has never held that an attorney's ignorance in this context deprives him of any deference. In other words, even in Kimmelman, where the Supreme Court of the United States said there is no way that this decision to not take a motion to suppress was a strategic decision. The poor attorney just thought that the government turned over all of the inculpatory evidence. The court still said, we're going to look at that with a fair measure of deference, a heavy measure of deference, and decide this for objective reasonableness. And that's exactly what the Supreme Court of Virginia did here. The Supreme Court of Virginia looked at the facts that the defense attorney faced at the time, and he made an eminently reasonable decision to avoid an all or nothing gamble. Going back a little bit and kind of addressing this from a reasonable investigation standpoint, which is how it was framed up here on appeal as opposed to an objection, going into trial, the defense attorney testified that he did not think that the robbery charge had a leg to stand on, because the evidence at the time was that Mr. Wright had not participated in any physical taking. His brother, Mr. Robert Wright, and this was always the defense theory, his brother, Mr. Robert Wright, was the one who was involved in the taking. Mr. Mark Wright, our petitioner here, was on the other side of the car that had nothing to do with him. In that context, there was no reason for Mr. Mark Wright's defense attorney to seek a lesser included. Instead, his strategy was to test the Commonwealth, put that to the test and expect it to fail on the merits. When the Commonwealth amended the indictment at the beginning of trial, the Commonwealth broadened that, and of course the strategy had to change at that point. And I think that that's a very important factor in this case. And I wanted to just briefly touch on prejudice.
Before you go to ineffectiveness, a little bit with Judge Harris' question, is your view on the deficient performance no harm, no foul?
No, Your Honor, I don't think it is. I think that
It almost has to be, because it can't be strategic because he didn't know he had an option. So aren't you really arguing that, well, he didn't know he had an option, but it didn't make any difference because keeping it in there helped his client?
I think that my position's a little more nuanced than that.
Okay,
I think that I'm going to try and nuance it for you, Judge. I think that I think that my position is that the interest in this case, and this case may be kind of an outlier, but the interest in this case of having that drop down on these facts and with this jury and how the trial was going outweighed whether he knew that he could object to that instruction. He wanted the instruction any day of the week. He was in trouble. His case was going down. He was worried about his client going to jail for a long time. And I think that kind of, and I know that it may not get the imprimatur of strategic decision that we have in the case law, but I think that kind of strategy can be illustrated by a hypothetical where he didn't object to this gift from the Commonwealth of a lesser offense, got convicted of robbery, and got sentenced to 20, 30 years for robbery. And then the habeas claim would be, why did you object to that when I had a drop-down option that I could have had? And I think that this is the kind of double-edged, condemned if you do, condemned if you don't situation that defense attorneys face every day.
Well, I don't think the counsel, I may be wrong, but I don't think counsel has an obligation at all to object to something.
No, Your Honor.
He had known that was wrong. That's not his job.
No, it absolutely is not. And I think that putting a constitutional duty on a defense attorney to bring the Commonwealth's errors to the court's attention so they can get fixed,
right?
That runs contrary to the ethical obligation of a defense attorney. And I actually did check that before I made this argument. I can provide some legal ethics opinions to the court if the court would like me to do that by 28J letter. They're a little bit older, but they're Virginia ethics opinions.
But is it, because it's not, I mean, I'm old, but so it's not a dinosaur, but it used to be a long time ago, people charged with drunk driving under the influence. You know, the judge want to give them a break, you know, in district courts. It's okay. I'll find you guilty of reckless driving. Yes, thank you so much. But reckless driving was not a lesser included offense of driving under the influence, but it was happy defense counts because, you know, a lot of implications with driving. SR 22 and all those things like that. So that was a long time ago, but I guess the question, it does get to, as Judge Harris said, if you're asleep, it doesn't matter that it turned out that it's a good thing you didn't cross-examine that witness because that helped you. But you said you can't take advantage of it when you're charged with deficiency because you didn't know you were doing that. I guess so. It's like if a tree falls in the woods, does it make a sound? Almost. That kind of, it's kind of interesting because counsel could do that strategically. A competent lawyer could have done that strategically. But here he says he didn't know. So the question is he barred from that because he didn't know, but a competent lawyer may have done the same thing with the same effect. But because she knew that that's what the strategy was, that's okay. But because he didn't know, same result, but then he may be deficient. Isn't that kind of like what we're talking about?
It is, Your Honor, and I'd really like to speak to that, but I know I'm out of time. Can I briefly?
Fortunately for you, you're talking to the chief, and so I can give you time. Go ahead.
Well, I really appreciate that. I think that that's a key issue in this case because the Supreme Court of the United States has told us over and over again that Strickland deficient performance is a matter of objective reasonableness. In Richter, the court said directly, Strickland is not concerned with subjective intent of counsel, but with counsel's performance. And I submit in this case, saying that just because, you know, if counsel had been asleep, then he, you know, he doesn't get the benefit of this. I think that means that a defendant whose attorney was perhaps ignorant on a point of law or was, you know, otherwise imperfect, has a different outcome than a petitioner or a defendant who says, my attorney did this on purpose. So I think that that's an incorrect application of Strickland. I think that the Supreme Court of Virginia was very careful in how it applied Strickland in this case and really threaded the needle. And I think under 2254 D1, this is a very high bar for the petitioner to overcome. The Supreme Court of Virginia has a real wide has a real wide latitude in how it applies that general rule. And I submit that the defendant can't pierce through AEDPA, and even if they could, still reasonable under Strickland. And I'd ask the court to affirm.
All right. Thank you, Ms. Johnson.
Thank you.
Mr. Short?
Your Honor, may it please the court. My name is Josh Short on behalf of Mark Wright. I just want to make a few points clear. First, the Supreme Court of Virginia applied the wrong standard when applying the maximally deferential no competent counsel standard.
Again, Mr. Short, speak up because you're trailing off.
Yes, Your Honor. The maximally deferential no competent counsel standard was the wrong standard in this case. And to respond directly to the state's point, Supreme Courts are not infallible. They get the law wrong all the time. And AEDPA is not a high bar when the Supreme Court applies just blatantly the wrong standard. The Supreme Court of the United States has been clear that informed strategic decisions are virtually unchallengeable. But that's not what we had here. Mark Wright's attorney had no idea that grand larceny was not the lesser included offense. Now, Mr. Wright was obviously prejudiced by this oversight because, you know, he has a duty to know the law, and that's clear from the Supreme Court's precedents. And our point.
No. Stick with what you just said. You said that he was clearly prejudiced. Now I want you to put some meat on that.
Yes, Your Honor. He was clearly prejudiced because he was convicted of a crime not charged and submitted to the jury without an indictment.
Okay, full stop right there. You're right. That's what happened. He was convicted of a crime that was not properly charged. I think we all agree, not a lesser included offense. So, but prejudice, now you said prejudice would be an outcome because of that hurt him. How do we know that? Are you saying that you could have made a successful or likely made a successful argument of a motion for insufficient evidence on robbery if he had been convicted of it?
Your Honor, well, I think the trial court dealt with that issue, and we're talking about whether grand larceny was an appropriate lesser included offense here, and trial counsel had not done the research necessary.
No, but you said it was a prejudice, but wouldn't that be the alternative in terms of, if you're going to talk about prejudice, you got to play it out a little bit, because you take out the offending thing and see what would have happened. So the offending thing was he should have said, Your Honor, excuse me, you shouldn't have that instruction in here because that's not a lesser included offense. Thank you, counsel. I appreciate you letting me know. Take it out. Same evidence goes before the jury. I'm asking you to have some prejudice now, because now we've taken the wrongful deficiency out. Would there be enough evidence to find him guilty of robbery in this case?
Your Honor, as the jury acquitted him of robbery, and as a factual matter, Mark Wright was on the other side of the card during this situation. And I think the existence that the state wanted to include a lesser offense made it seem like they were uncomfortable with going all or nothing on the robbery charge. And if Mr. Wright's attorney had done his constitutional duty and suggested the petite larceny instruction, that is what the Constitution requires, is for him to know the law, and he failed to know the law in this situation, and that prejudiced Mr. Wright. He spent 10 years in prison for stealing a case of beer and a couple sandwiches. And that's what this case comes down to, is the fact that the state had the prosecutor in this case. Sorry, Your Honor.
I guess that's the question. And I don't know the answer necessarily. I think I'm intrigued by this. I really want to be informed, because I see what you're saying. He does 10 years in prison, but it turns out that it wasn't grand larceny. But the thing is that you're assuming that without the grand larceny, they would have said, oh, no robbery, petit or petite larceny?
Yeah, Your Honor, Strickland requires us to assume that the jury did its job. And here the jury acquitted Mr. Wright of robbery. And, without this error from counsel, from failing to do the necessary legal research, he would have never spent the last 10 years in prison. It's more than likely that he would have been out in 12 months. But the petite larceny instruction was the maximum amount of death, or the maximum amount of jail time that he could have served under petite larceny. And I think prejudice is clear.
Can I ask you one last question?
Yes, Your Honor.
If in fact, this is hypothetical, it's a counterfactual, not this case, but very close, but not this case. If he knew that that was a erroneous instruction, and said, I know this is not right, but I think it's a chance that they may give him robbery, so I'm going to let it stay there. If he did that, and they found him guilty of grand larceny, would that be deficient?
Yes, Your Honor, because the grand larceny required the trial counsel to acquiesce to an illegal instruction, and it also was not the actual lesser included offense of robbery. And so it would have been deficient for the fact that it was both illegal, it was unreasonable, and, Mr. Wright has suffered prejudice from that. He spent the last 10 years in prison because of this decision. And I think Judge Harris had it. Oh, sorry, Your Honor.
So your position is, whether it would have been helpful or not, the fact that he didn't move to strike it was deficient, whether it helped him.
Your Honor, I think Judge Harris had it exactly right, that the deficiency was the failure to know the law. And that decision influenced his ultimate omission to not object to the situation. And Your Honor, I see my time has expired. I'm happy to answer more questions.
Well, I take up your time, so I got, go ahead.
I just have one more question. So I think you're right. His ignorance of the law influenced his decision not to object. And I think his desire for an alternative to robbery, there's testimony that influenced his decision not to object. Which makes this, I guess, kind of hard, because we got two things, and I guess, and your point seems to be that the first part of his decision making, wipes out the second part. And I guess I understand that. Is there, given the standard that we look at, is there a case like this, where there were dual reasons, dual justifications, one of which was erroneous and may have been deficient, but the other is strategic? And the reason I ask that is, we're looking at least in part as to whether this is an unreasonable application. And so what's the closest case in that situation, so we can apply that part of the test?
Your Honor, I think this is a pretty bizarre situation. And I think, I'm just being honest, and I think I would refute that there were two possible outcomes here, because Mr. Wright's attorney failed to do the necessary research. And he could not have formed a strategy. He didn't understand the relevant considerations on both sides. You can say that he wanted to limit his sentence, or Mr. Wright's sensitive exposure, but good intentions are not good enough for the Sixth Amendment. And it required Mr. Wright's trial counsel to look into the relevant law, and once he understood those considerations, then to he had to object in that situation, because that was an illegal instruction, and it would have been totally reasonable for him to go all or nothing on the robbery charge, because the evidence was weak in the situation. But it was also reasonable for the petite larceny instruction. I think both of those outcomes are totally reasonable professional merit, but the error was the failure to do legal research back. I mean, this is a crucial part of the case. This is when the rubber hits the road. This is how long is my client going to be sentenced to jail time? And counsel came unprepared to answer that situation, answer that question.
Well, the jury, as you know, in Virginia, the jury recommended sentence, right?
Yes, Your Honor.
And what's the low range of grand larceny?
The low range is 0, but
no, the low range is 0. No, I don't. I'm talking about the sentence range. I mean, if you found not guilty, that's 0. I'm talking about sentencing range.
Yes, Your Honor. I think the sentencing range for grand larceny is 0 to 20 years, which is
right. What did they recommend for him?
10 years, Your Honor.
Do you think it's likely that they would have found him guilty of petit jury if they felt 10 years was sufficient?
Well, Your Honor, grand larceny should have never been submitted to the jury in the first place because it was.
No, you're missing my point. Never mind. I see. Okay. All right.
Thank you, Your Honor. I'm happy to answer more questions.
Thank you. All right, Mr. Ballinger. First of all, I note that you're court appointed. Yeah, please come up. Yeah, I'd like to see our students here. Okay. Make sure you keep your social distance. But no, I just want to say that thank you so much. You're court appointed on behalf of the court. We really appreciate that because it helps us so much. Particularly in cases like this are very thorny and tough issues and rather somewhat novel in a sense. And, I just want to thank you so much. And students, you certainly acquitted Mr. Jefferson's school very well today. And we thank so much for being here. Ms. Johnson, thank you so much for your able representation of Commonwealth as well. And with that, we can't come down and greet you. I wish we could, but we cannot. Thank you for being here. Appreciate it, and hope you will all be safe and well. Thank you so much.
Thank you, Your Honor.
All right. Adjourn the court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.